Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is our very special guest, Andrew Branca from Law of Self-Defense. How are you, sir?
I'm doing awesome. Glad to be here. Thanks for the invitation.
Oh, it's my pleasure. I'm so happy to have you on. You are the guy on self-defense law. That's my understanding is that's the focus of your practice, and especially tackling these high profile sort of cases. I know you wrote a lot about the Zimmerman case, for example, and other self-defense type shooting situations. So
I do. All we do is use of force law. So defense of yourself, defense of other people, defense of property. Anything involving use of force. We don't have a generalized criminal defense practice, so we don't do DWIs and shoplifting and drugs and stuff like that. It's strictly use of force law. Yes,
and that is probably for the better, because defending all of those other things is tedious. I'm sending you a link to the chat right now. You had asked me to see the comments and stuff that comes on, so that is there. Now I have to figure out how to get that chat window to go away. There we go. Okay.
Okay, I see it. Great. Awesome.
Yeah, so the chat is here, and they will filter in really over the next hour as we get going, as YouTube's notifications go out. But we are here to talk about the Ahmaud Arbery case. And this is the shooting that occurred in Georgia, and there is much information out there. And I just say information because it's not good or bad information. It's all information is out on this case. And you can find different opinions of what happened out on the internet and on various media sources. For me, the only information I've taken in on this case really is the pretty terrible cinematography aside, the terrible cell phone video of the incident leading up to the shooting from the gentleman in the car that was following Mr. Arbery as he was running through the neighborhood. So other than that, I have seen some of the footage about the alleged robberies and stuff like that, which those do seem, assuming that's him, those do seem to be within the statutory definition of robbery in Georgia. So I've seen the photos of him in the construction site, and then I've seen the videos. But other than that, I have not taken in too much information of the facts of the case because I tend to not trust the media narrative on it. I also know that as facts materializes in these types of cases, things get often you get privy to some useful information that might have been left out early on. So what I was hoping you could do is kind of give the audience a rundown of the factual situation of the case as best as you have without any of the sort of media spin on it.
Sure. So, of course, there's a couple of competing narratives here, as there are in any kind of criminal defense take. There's the narrative of guilt, right? Why the defendants in this case are the most horrible people that have ever existed, and the narrative of innocence, which is why what they did was actually within the bounds of the law and they shouldn't have any criminal liability. And the narrative of guilt, as communicated by the media, is essentially that these two white supremacists killed a black guy for the crime of jogging. That's the narrative of guilt in the case.
Of course.
The narrative of innocence is more along the lines of, Georgia has a very broad citizens arrest law. They were acting in the course of a citizen's arrest. That makes their conduct lawful. And at the end of the citizen's arrest, they were in fact attacked by Arbery and were simply defending themselves at the end. So that's been kind of the generalized narrative of innocence. In fact, as I'll explain over the course of the show, I think it's even simpler than that. I think this is really a very simple case, not a complicated case. It's made complicated by much of the misinformation and disinformation that's been shared in the media, and a lot of conversation, YouTube videos, Facebook posts, often by prominent people, sometimes in the gun community, who have come to conclusions based on imperfect understanding of the law, imperfect understanding of the evidence. And of course, there's the whole racial dynamic as well, which kind of biases everyone to be as, present themselves as super anti-racist as possible, which is fine, except it can lead people to simply faulty conclusions about what's happened based on those misunderstandings of the facts and the evidence.
Yes, the race element in all of the use of force cases that get picked up by the media, which are, from my perspective, about the only use of force cases that get picked up by the media are the ones with the racial dynamic to them. Those always do seem to focus on social issues rather than on facts as applied to law. And it develops a narrative, and then overcoming that narrative tends to be very, very difficult.
It's really impossible.
Right.
It's impossible. I mean, in a courtroom, you can sometimes overcome it because of the constraints of the courtroom, because of the rules of evidence, and it's a very restricted and controlled environment. But out in the public, it's uncontrolled. And you mentioned before we went live that you're aware that I covered the Zimmerman trial, for example, very closely. In fact, I watched every minute of the trial. I reviewed the entire discovery file before the trial even started. I watched most of the pretrial proceedings. So I'm as familiar with that trial as the lawyers who would lead counsel on the case, who I've come to know personally since then. And so I know what was actually presented as evidence, what the arguments were, what was credible in that case. And it's completely different than the popular conception of that case. I mean, the popular conception was people were shocked that Zimmerman was acquitted. It was no surprise to me at all that Zimmerman was acquitted. In fact, based on my view of the evidence, there was never a prospect that there would be a conviction. There was never a prospect that the prosecution was going to be able to prove George Zimmerman guilty beyond a reasonable doubt of a crime in that case. But I understand that most people didn't watch the whole trial. Most people didn't see the evidence file. And if all you know about that case is what you heard in the media, if all I knew about that case was what I heard about in the media, I'd be outraged too. It would look like an injustice to me too. So I can certainly understand how people have the misconceptions they have about that case. And the same thing's happening here, as far as I'm concerned. The same people are involved in terms of developing the public narrative around this case, the Al Sharpton, Benjamin Crump, their allies in the media. I see the same kinds of very selective presentation of 911 calls, of photographs of the people involved. It's much of the same techniques in terms of communication that are being used. And so it's totally my expectation that the general public is going to walk away from this case whenever it's done with whatever the media presents as the view of the case, and what actually happens in court, whatever the approximation of truth is that comes out of the criminal justice system, won't necessarily have any relation to how people perceive the case to have turned out. Right.
Can we let's talk about the Zimmerman case for a little bit, since you're very well read and listened and all of that stuff on the case. I was pretty sure Zimmerman was going to be acquitted of any wrongdoing, mainly because for me the entire case boiled down to the simple question of, at the time of the altercation, was he in fear of his life to the point where he felt deadly force was necessary, and would a reasonable person fear to do so? And the moment that I heard that Trayvon Martin was on top of him, hitting his head on the concrete, I thought, once you've got a head wound, and there's some photographic evidence of that head wound. Once you've got that going, it's going to be pretty hard to say, even if you thought that Zimmerman was in the wrong following the guy, even if you thought that he did every wrong move up to that point, that guy deserves a death sentence for doing those wrong moves, runs kind of counter to the idea of self-defense law. That in the moment he's getting his head bounced on concrete, he's justified to pull out a gun and shoot someone, because he becomes in reasonable fear that he's about to be killed. That's where I ended up on that. I don't know if you have a different take on it than that, or if I missed something, but that was my sort of read on that case.
Sure, I think that's largely correct. I think where most people get tripped up is they think that Zimmerman did things beforehand that should have lost him self-defense, that he somehow provoked the confrontation. For example, it's very common for people to believe, and by the way, I lecture at the FBI Academy at Quantico, and I present these issues to them there. And this is an audience of federal agents and very senior level law enforcement from all over the country. And I asked that audience, how many of you, by a show of hands, believe that George Zimmerman got out of his car after being told by the police not to get out of his car? And at least 3/4 of the hands go up. And
Yes.
folks, I bet if we look in the comments here, if we ask that of your audience, most people will believe that's true, that happened. Folks, that never happened. And we know it didn't happen because we have the entire recording of the 911 conversation between Zimmerman and the dispatcher. And we know he was never told not to get out of his car and then got out of his car. That's a complete fiction. But if you hear it in the media 10,000 times, of course, you come to believe that that must be true. If you watch the trial, you know it's not actually true. And there's a lot of those events through the course of the kind of narrative that was created around Zimmerman. I saw a comment already in here that says, oh, gosh, Andrew's a Zimmerman defender. I don't care about Zimmerman any more than I care about the McMichaels. I'm just a lawyer, folks. I don't care about these defendants on any kind of personal level. I don't know them. They don't mean anything to me. I only care about the evidence and the law. And unfortunately, there are liars out there who sell us misinformation about these cases. And if we swallow that misinformation, we're misled as to what the truth actually is.
Absolutely. And what really got me, this is after the Zimmerman case, but what really blew my mind was the Mike Brown case. Mike Brown and Officer Darren Wilson in wherever that was, Ferguson, right? When Officer Darren Wilson shot Mike Brown, and the hands up, don't shoot thing was a very popular narrative, and it kept going. And then one day I was sitting at my parents' house. My whole family's over at my parents' house, and I was sitting, and someone else was watching my kids. So I'm like, oh, thank God. So I pulled out my phone and I found a link to the grand jury transcripts. And I started reading through them, and you started to find very quickly that everybody who was interviewed by a news person, no matter what they said in their news story, none of that was backed up by any of their grand jury questioning. Once they were under oath and once they were put under that penalty of perjury, and they know they're in an official process, everybody started saying, actually, I didn't see it. I just heard some gunshots. I just heard this. I didn't see what was going on. And that
everybody was saying it, so it must be true, right?
Right.
If everybody is saying it, it must be true. And now you want to be part of the club. And some of those witnesses who swore to investigators that they saw Michael Brown on his knees with his hands up, begging for his life, were blocks away. We're behind buildings. We're obviously incapable of seeing what they claim they saw. And of course, fortunately for Darren Wilson, that wasn't that hard to discover. They found it in the grand jury process, as opposed to, forcing him to endure the hell that is a criminal trial and the expense of that criminal trial. The truth came out earlier. And the truth is, the truth came out in that case at the grand jury level because the prosecutor wanted the truth to come out. That prosecutor was willing for the truth to come out. It's a very different case when you have a prosecutor who sees a case like this as an opportunity for professional and political advancement, a career-making case. That prosecutor is going to get the indictment. If the prosecutor wants the indictment, they will get the indictment and bring the case to trial, regardless of the merits of the case. In the case of Zimmerman, the prosecutor was Angela Corey. She was running for re-election. She was having a very difficult re-election race, particularly in the Black community, because of some very unpopular Black defendants she had prosecuted, including a 13 or 14-year-old Black boy for the crime of murder. She prosecuted Marissa Alexander, who some of you may remember fired the shot into the ceiling to frighten away her abusive husband. Fired the shot into the air. The bullet actually hit the ceiling. It hit the ceiling after zipping past his head, because the bullet was actually in the wall behind him. So that was a miss, folks. That was not a warning shot.
Well, that's just her being bad at shooting the ceiling, I think.
Right, she was bad at shooting the ceiling. But Angela Corey, the prosecutor, she was not going to get reelected. Zimmerman popped up on a radar screen. She knew, if I prosecute Zimmerman, And she knew there was no merit to that case. She knew the chances of getting a conviction were as close to zero as you could possibly have. But her mission in trying that case was not to convict Zimmerman. Her mission in trying that case was for her personal political advantage, to gain favor in those demographics of her community that were against her for re-election, that were marching against her in the streets. When she prosecuted Zimmerman, she was at the head of those marches. She was popular again, and she won. She won re-election. So from the legal perspective, Angela Corey lost the Zimmerman trial because he was unanimously acquitted of every single criminal charge, and they threw a lot of criminal charges at him. But in the real sense, for the values of winning that mattered to her, she won the case because she won re-election, and that's what mattered to her.
I want to bounce back to two things that you just talked about. One, the prosecutor in the Darren Wilson case. I just want to point out that he was excoriated by the media for how he conducted that grand jury, because he allowed and prosecutors don't have an obligation to do this, but he allowed exculpatory testimony to come in front of the grand jury. And grand juries are this unique thing. They're not held to the same rules of evidence or the same evidentiary standards that you are in a regular courtroom, because the question is just, is there probable cause to bring a charge in this case? And so they allowed they're typically allowed to use evidence that might not be admissible because they feel like upon getting the charge, they'll be able to draw something out either through interrogation or further discovery. He did not take that approach, and I think it's to his credit, because he said, look, they could rail Darren Wilson at grand jury, and they could have absolutely gotten those jurors to bring charges. But instead, he did see a lot of problems with the case, and he said no, and he brought in exculpatory evidence there. The other thing I wanted to go back.
I think he lost his job over it.
Yeah, that's tends to be how that goes.
Right.
It's really, it's an unfortunate mess. Prosecutors are incentivized by prosecuting. They're not incentivized necessarily by getting to the actual facts. And that's not a dig on prosecutors, just like saying that a cop's job to arrest someone is not a dig on cops. It's just a function of the role and the one thing I tell people when I tell them don't talk to cops, always have a lawyer present when you're talking to these people, all of those things, is not a slight of those professions. It's a respect for their ability to do the job that they have. Like, their job is to arrest someone, and then the prosecutor's job is to get a conviction. They're good at that. And so you need to take all of the cautions.
They're professional interrogators. I mean, they're trained. They do this every day. This is what they do.
Right.
When they're questioning you, this is just a normal day on the job for them. They're pros. You're not a pro. you don't know how to deal with an interrogation. Plus, you've probably just been through one of the most stressful experiences of your life. You're not at 100% by any stretch of the imagination. No, it's crazy. And again, it's not because the investigators are bad people or the prosecutors are bad people. This is what we hire them to do, right? We pay detectives to be professional interrogators. We pay prosecutors to identify what they perceive as bad actors in society, bring them to trial, prove them guilty beyond a reasonable doubt if they can, and get them sentenced so that law-abiding people in society don't have to deal with these violent actors. This is what they're doing. I know a lot of prosecutors. They're almost every single one is a very hardworking civil servant in the system trying to do the best job they can. But prosecutors also get unbelievable discretionary authority. And if there's a bad actor who gets that job, the devastation they can wreak in their community is unbelievable.
Oh, yeah, it's massive. The other thing I wanted to go back to just briefly on the Zimmerman stuff. Have you followed the Trayvon hoax documentary and the flare up around that at all?
Yeah, so the answer is really no. I haven't watched the documentary. I haven't looked into the civil suit. My interest is not, I have no interest in that stuff. I'm interested in the use of force trial. So I follow that very closely. I do, having observed the trial, I do very strongly believe that a number of the prosecutors involved ought to have been severely sanctioned, if not disbarred for their conduct. They hid exculpatory evidence. They did some really despicable and, in my opinion, unethical things in the course of that trial. Unfortunately, the legal system in Florida decided not to do anything about any of that. So I think Zimmerman was badly persecuted by the criminal justice system in Florida. Now, as far as his specific claims in this lawsuit, that a witness was switched or whatever, Jantel, I forget her name now.
Yeah.
I don't know anything about the merits of that, and I don't really have any interest in that. But if Zimmerman were to manage to get some money out of these prosecutors who did things like hide exculpatory evidence, I think he's fully entitled to it.
Yeah, and that's one thing that I hope maybe we'll kind of touch on, at least through the course of the interview, is I think, and you're probably the most uniquely qualified person maybe on the planet to answer this question, is even when these people win these highly publicized cases, especially the racially charged one or some other demographically charged issue that the media latches onto, is there a win for them? I mean, the win is not going to prison, but what do their lives look like after?
Yeah, when you win, you lose.
Right.
I mean, Zimmerman won, right? He won an acquittal, unanimous acquittal on every single criminal charge they brought against him. And believe me, it wasn't just second-degree murder. They found every lesser included charge. They even tried to add on a child abuse charge at the end of the trial because Trayvon Martin was technically a minor. So he used force against a minor. They couldn't get him on second-degree murder. They couldn't get him on manslaughter. They couldn't get him on aggravated battery, aggravated assault. They couldn't get him on the child abuse charge. They couldn't get him on anything. That's as big a win as a defendant could possibly hope for. And by the way, an investigation and trial that took 14 months. I mean, you'll know as a criminal defense attorney, most murder trials are a couple days, 2-3 days, and they're over. This trial went on for weeks and weeks and weeks. And he got acquitted. So that's about as big a win as you could possibly hope for. But guess what, folks? His life was utterly destroyed. He lost everything. He lost his job, his wife, any hope for a normal life. And for years after that, all this weird behavior we know about Zimmerman, the weird paintings, the fights with girlfriends. Folks, if the state of Florida had spent 14 months trying to kill you, which is essentially what they were trying to do, if George Zimmerman went to prison, in a Florida prison, he wouldn't last a week in a Florida prison. So they were effectively trying to kill him for 14 months when he, in fact, had done nothing wrong. In fact, he was the good guy in that confrontation, the good guy in his community. Florida was trying to kill him because the prosecutor wanted to win an election. If you'd been through that process, do you think you might suffer some PTSD, even having been acquitted after the fact, when you've lost everything as a result and the entire world thinks you're a racist killer for the rest of your life? Yeah, and the guy was broken, folks. Like, I think anybody would be broken from that process. In fact, it's only the last couple of years he seems to have gotten his bearings back and be functioning like a reasonably healthy human being again. But those first 3 years after that acquittal, yeah, the guy acted weird for a reason.
Yeah, it's and being accused of really any crime that's a serious crime that carries a long potential sentence, which a long sentence, I think, to most people is any amount of jail time, really. But so once you're charged with a serious crime, to have that hang over you is something that is that even most criminals don't know what that's like. Usually, if you're exercising your right to a speedy trial, your criminal trial from arrest to conviction or acquittal is 2 to 3 months total time. To have something dragged out like Zimmerman's case or the OJ trial or really any of these high profile cases. One that I like to talk about up in Minnesota was not a murder case at all, but is this guy named Harold or Howard Root. He was federally charged for deceptive advertising. He owned a medical device company here in Minnesota. He was under federal indictment for something like 18 months. And front page of every newspaper in the Twin Cities is talking about how this guy is a felon, a criminal, and he faced 25 years. He ended up having to spend something like $20 million to defend himself. And it turned out what they charged him with, he didn't even, not only was what they charged him with incorrect, but if everything they said that he did, he actually did, it wasn't illegal. And the defense was literally, the prosecution rested, the defense just stood up and said, defense rests, Your Honor. And that was that. But I listened to him speak and it ruined his life. It flat out ruined his life. And this guy is not impoverished or anything. He's closing in on a billionaire and was at the time as well. Very well off, but there's nothing that can shield you from that level of scrutiny and daily grinding on people. So yeah, I think it's
the process itself becomes the punishment, even if you're acquitted at the end. And by the way, folks, what if you don't have 20 million for legal defense?
Right.
What are you doing? right? Because we'd all like to think we live in a world where the amount of money you can bring to a legal fight doesn't affect the justice you will get, but that is not the world we live in. A legal fight's like any other battle. The more resources you can bring to that battle, the more likely you are to win that battle, all other factors being considered. And I can tell you, there is a world of difference between, if you're charged with a killing charge, a murder or manslaughter charge, there's a world of difference between a $30,000 legal defense and a $300,000 legal defense. They are not comparable. And the prosecution knows that, by the way, going in. He knows the resources you're able to bring to the fight.
Oh yeah, absolutely. Okay, well let's get into this the factual sort of rundown of Ahmaud Arbery's case in Georgia, or the Ahmaud Arbery case. And I think it's just to point out, I think it's an intentional function of the media that we know the deceased name. I have no idea the names of the shooters.
Yeah, so the shooters are they're a father and son. The father is Greg McMichaels. The son is Travis McMichaels. The father is a retired law enforcement officer / in his later career, he was I guess a non-sworn investigator for the local district attorney's office. In which position he didn't have arrest powers. Not that that's relevant here, but just to provide some context. At the point these events occurred, he was simply a civilian, just like any of us.
Right.
And his son was, he's in his, I think, 60-something. His son is 30-something. Otherwise, until this event, normal law-abiding people never been in trouble with the law a day in their lives.
Sure. So my understanding is the facts that we know is this, the deceased, Ahmaud Arbery, was inside an unoccupied construction site somewhere near where the McMichaels live. Is that accurate?
Right.
Okay, so it's
basically directly across the street.
Sure. And they witnessed him, I believe, on multiple occasions, or I'm not clear. Is it multiple occasions that they witnessed him enter the property, or was it just this particular day?
So we don't know. That those facts are ambiguous. They did witness other black males, or I should say black males, on previous occasions enter the dwelling. We don't know if it was the same person or not. We don't know if they think it was the same person or not. It's very ambiguous, but it's not important to the facts of this case, really, whether or not they observed it in the past. All that matters for the facts of this case is they folks, I'm going to kind of abridge the facts. I'm not going to leave out anything that would influence our kind of legal analysis here.
Right.
But otherwise it gets too complicated and too detailed to cover in this kind of setting. But in effect, they observed Arbery exiting the private property, believing that he did not have the right to be there. So it was a trespass that had taken place, criminal trespass. Under Georgia law, if someone criminally trespasses, even in a home under construction, with the intent to steal, that's a felony burglary. And it doesn't matter if they actually steal something or not. All that matters is they unlawfully enter with an intent to steal. If they get in there and there's nothing to take, or they get scared away, and it's a quote unquote failed felony burglary, it's still a felony burglary under Georgia law. And I want to be very specific about this because these laws are different in different states. Citizens arrest law in particular varies wildly across the states. So when we talk about these laws, if you have an understanding of what those laws are in your state, don't assume they're anything like Georgia. Okay, that's a mistake that people often trip up on. So they observed what could have been a felony burglary. Now, of course, we don't know what Arbery's intent was, right? Did he have an intent to steal? We know he went in unlawfully. There's no question about that because we have video. So the unlawful entry was given. That's a simple trespass right there, which isn't all that important. But if he entered with the intent to steal, now it's a felony burglary, which changes the crime completely. Up to 20-year sentence for felony burglary under Georgia law, by the way. And you don't have to take anything.
Now, can I pause you for 1 second?
Sure.
If I'm not mistaken, the Georgia law was amended to include the failed burglary as a burglary somewhere in the 70s. Is that accurate, or are you familiar?
I wouldn't know. I don't know the history of that law. I know a little bit about the history of their citizens arrest law because it's an interest of mine, and I've researched that.
Sure.
In terms of the felony robbery law, all that matters is what the law was at the time the event took place.
Gotcha.
And by the way, Georgia has a very broad felony burglary law. So it's not just dwellings. It's like this: homes under construction, tool sheds qualify for felony burglary. If you go to like a Home Depot and they have that chain link enclosure where they keep building supplies inside it. If you unlawfully enter that with the intent to steal, that's felony burglary. So it's a very broad felony burglary statute. Another thing I should mention, folks, right up front, two things really. One is it's very important not to conflate poor judgment with criminal conduct. I think a lot of us would agree that the McMichaels, both of them, engaged in poor judgment. I would never encourage anyone to pursue a citizen's arrest, to chase someone down. I think that's a very high risk endeavor to undertake. It's not worth the risk, the benefits, the upside is not worth the downside. And anytime you get engaged in this kind of potential confrontation, of course, this one turned into a real confrontation, you've incurred two risks that you weren't incurring a moment before and don't need to incur. And that is a greater than zero risk of dying in that fight, which almost happened here to the McMichaels, right? And a greater than zero risk of spending the rest of your life in prison. So I don't want to encourage anybody to be making a citizen's arrest. I think you're crazy if you do that. I think it's poor judgment to do that. But that's not the same as it being a crime. Whether or not it's a crime is determined by whether or not what the McMichaels actually did violated a Georgia criminal statute.
Right.
So it's two different questions. So when I start talking about how I don't think they violated this statute or that statute, I'm not defending their judgment. I think their judgment sucked. But just because your judgment sucked, it doesn't mean you broke the law. Those are two different things.
Sure.
The other thing I wanted to mention, now I can't forget, but I'm sure it'll come back to me as we talk through the case.
Real quick, Andrew Binns just has a comment, says, great guest. Also, the juxtaposition of your offices is amazing. Look, I'm going to need you to get more nerdy stuff behind you rather than like cool like diplomas and stuff like that.
Well, what they call it, my love me wall.
Yeah, so. There you go. Okay, so yes, I think that's one thing that people are missing is one, I think burglary is misunderstood, but burglary is entering a dwelling with the intent to commit a crime at a basic level. Whether or not you actually commit a crime, that would be in addition to the burglary. So if you did go in and steal something, you're charged with a burglary and a theft. That's one sort of thing here. The next thing I wanted to talk about was let's get to that citizen's arrest law. And this is where I have some questions regarding, I did a cursory look at some of the case law around it. And so I have some questions to pose. But basically, well, why don't you let the audience know, I guess, the understanding of the citizen's arrest law in Georgia and why it might be different from some other states?
Sure, happy to do that. Before I do, though, I remembered the second thing I wanted to mention, and that is, in addition to not conflating poor judgment and criminal conduct, those are two different things. You can agree the McMichaels engaged in poor judgment, doesn't necessarily mean they broke the law. That's a different analysis. The other thing I wanted to mention is we could all agree that some of these Georgia laws, like their citizens arrest laws, are bad laws. The Georgia Citizens Arrest Law was first written in 1863. It was last revised in 1933. This is an almost 100-year-old statute from the last time it was visited by the legislature. I can assure you, and anyone who's done criminal defense work can tell you, anyone who's been through law school can tell you, in the last 100 years, what the police are allowed to do in terms of detention, stopping, questioning, arresting someone has changed dramatically over the last 100 years. And this citizens arrest statute has not kept up. This citizens arrest statute reflects the mores and standards of society in the 1930s, which, by the way, was a time when many people didn't have a professional law enforcement agency they could call when there was a robbery or a burglary or a criminal act. The citizenry was the police. Right. That's why they had this statute. It was expected that the normal law-abiding citizens would make an arrest of a fleeing felon, for example. That was the norm. And it may be that we look at it today, we say, oh my God, that law is so outdated. That's not the standard we should apply today. And I think many of us would agree that that should not be the standard we apply today. If there was a drastic revision of Georgia citizens arrest law, if Georgia said, you know what, looking at this again, we think there should be no right of citizens arrest, period. A private citizen has no right to arrest another private citizen under any circumstances. I think that would be a perfectly reasonable public policy debate to have. But these defendants have to be judged by the law as it existed at the time they committed their acts. And if that's a law from 1933, that's the law they need to be judged by, not the citizen's arrest law we might imagine in our heads would be better if Georgia had it.
Yeah, and I've got a quote, and this is a quote from Johnson v. Jackson, which is a 1976 Georgia Court of Appeals case, and it's citing a Supreme Court of Georgia case for Long v. State. But it says, it's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon. And after a felony is committed, any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. So just kind of going back to what you're saying, when this law was written, the idea of policing is something completely different. I talk about this from time to time. The police was a reactionary force. They were not preventative in any real measure. And it was they're actually saying that it is a duty, a duty imposed upon the citizen of the state to arrest someone. Whereas
you mentioned that case is from 1976. I looked at the case law on citizen's arrest in Georgia, and most of the quote unquote recent case law on citizen's arrest in Georgia is from the 1970s. Folks, 1976 was the year before I went to see Star Wars opening night in the movie theater. Okay, that was a long time ago. And that's among the most current court decisions we have in Georgia on their citizen's arrest law.
Right. It's one. I do have one case that I want to talk to you about as we get going. And this is McPetrie v. State in 2003. But we'll get to that when we talk about the citizen's arrest. So,
Sure.
So Georgia citizen's arrest law basically says if you have the requisite probable cause, I think that's an easy way to summarize it, that a police officer would have to believe a crime, a felony level crime. And we have to distinguish that, I think, right?
Absolutely.
Because you don't have the same authority if we're talking about a misdemeanor. And that's what you mentioned before when you said, look, if it's a trespass, it doesn't matter as much. Once it's a burglary, that sort of changes things.
Right. So the way Georgia's citizen's arrest law statute works, and it's a very simple statute, folks. It's only 2 sentences. The first sentence sets out kind of the generalized conditions that have to be met before you can arrest somebody as a private citizen. And it could be for any offense. It doesn't specify. So either a misdemeanor or a felony. If you have immediate knowledge of the offense or you're personally present for the offense, that's sufficient to make a citizen's arrest. But the second sentence addresses a special case, and the special case is if you're dealing with a fleeing felon. If you're dealing with a fleeing felon, you do not need to have been personally present for the offense, and you don't need immediate knowledge of the offense. You need reasonable and probable suspicion. Now, what does that mean? The truth is we don't know what it means because it's language from 1933, but the way the district attorneys in this case have treated that language is probable cause, like probable cause would be required for a police officer. So if you're dealing with a fleeing felon, you don't need to be present. You don't need immediate knowledge. Probable cause is sufficient to make that arrest. Very much like a police officer. That arrest would be as lawful as if a police officer made that arrest under the same probable cause standard.
Gotcha. Now, I did see a case. I don't remember the citation of this one, but I did see a case that I think maybe clarified that. And that was where someone was engaged in an altercation, they withdrew from the altercation and then came back to it with the use of force for context of the case. And then they tried to use the justification defense, and the court said, no, not unless they not only withdrew from the encounter, but they notified someone that they were withdrawing from the encounter and then returning to effect an arrest using the use of force. Do you know anything? Do you know anything about that? Or I'm probably explaining it poorly, but
I don't. I'm not sure what case you're talking about there. There is a case that some people have been throwing around where a defendant tried to claim he was making a citizen's arrest when he beat someone with a baseball bat. And the court would not allow that because, folks, even if citizen's arrest is allowed, you're not allowed to use deadly force to effect a citizen's arrest. By the way, the police are not allowed to use deadly force to effect an arrest either. They're allowed to use deadly force if there's an imminent threat of death or serious bodily injury to some innocent party, either themselves or some other person. But if you're not compliant with an arrest, they will use force to compel you to comply, and they'll keep using more force as necessary, but they can't go to the deadly force level unless there's a deadly force threat from the suspect. So this is all perfectly normal. You can't use deadly force to affect, and I use as in a technical way here. I don't mean threaten. I don't mean apply. I mean actually using force against another person, deadly force threat. You can't do that for a citizen's arrest. So if you see a case where citizen's arrest was disallowed because somebody beat someone with a bat or shot somebody, well, that wouldn't be allowed anywhere. That's never allowed to use deadly force simply for the purpose of making an arrest alone.
Sure. And I think that probably is that McPetrie versus State case. I know there's a plastic baseball bat that was used, and then a wooden baseball bat that was that the guy was poked with. He wasn't actually bludgeoned with a wooden baseball bat. Sounds like they were just thwacking on him with a wiffle bat, which is kind of weird, but I guess that would be unpleasant without doing too much permanent damage. But anyway, okay, so getting back to the nuts and bolts of this factual scenario. So they allegedly have the immediate knowledge requirement to pursue a citizen's arrest. So
well,
then
maybe not, because they didn't observe him. I think they observed him leaving the property, which just be a trespass. Of course, I see people in the comments here saying, well, intent wasn't proved. Folks, intent's never proved in any absolute sense. We don't have a machine that reads people's minds. So we don't know what their intent is. It doesn't show up on a computer screen. Intent is always inferred from circumstantial evidence.
Right.
So it becomes a judgment call. For example, if they, and I'm not saying this happened, this did not happen, but just as an illustrative example, if they had seen Arbery running out of the home with apparently an object stuffed under his shirt, right? Well, from that, they can infer that he not only entered and trespassed, but also stole property. Here, it's more ambiguous whether or not he entered with the intent to steal. We don't know. But again, the important thing is they don't have to know with any degree of certainty that he stole anything. That's not the requirement. They don't have to know that he committed a felony. He doesn't have to have committed a felony at all. What's required is, do they have reasonable suspicion that it could have happened? That's the standard for making the arrest. And we may not like that standard. We may think that standard's too low. We may think the Georgia citizen's arrest law is too broad, but that is the standard. Now, the question then becomes, well, would a reasonable person perceiving Arbery's conduct have a reasonable suspicion that he entered for purposes of theft? What did they see? Well, we can all see it on the video that we observed. He walks down the street, stops in front of the house. He looks around, maybe to see if there's witnesses, anybody observing him. He walks into the building. He's there for several minutes. He comes out, and then he flees down the street. You can call that jogging, or you can call that fleeing from the scene of a felony robbery, right? It becomes a judgment call. The question is, would that conduct be sufficient to raise a suspicion? If a police officer observed that conduct, would that police officer feel he was authorized to stop Arbery and ask him what he was up to? I would think the answer would be yes.
Yeah, I think so. The distinction, and this is fuzzy, and so it's not really a counter argument, but the fuzzy question is, if it's just a stop and ask, stop and ask questions, we don't need to determine whether they had reasonable suspicion that he was committing a felony. But for the pursuing a fleeing felon standard, we kind of do, right? And so a cop can stop
I don't know if we do.
Well,
that's an interesting facet of this case, actually.
Sure.
In fact, I'll give a spoiler right now. I don't think citizen's arrest has anything to do with this case, whatever. So I think the citizen's arrest statute is completely irrelevant to the entire case from beginning to end. I think people are tripping over it in error. So
Sure.
I just spent a lot of time talking with you about the citizen's arrest statute because people are interested. They want to know how it works. But personally, I think it just doesn't matter to this case.
Well, I feel hurt that you've done this to me. No, I'm just kidding. Okay, well then let's get past that, because I do think there's a fuzzy aspect there. If the citizen's arrest statute requires them to know with reasonable suspicion that a felony has been committed, that's one thing. Whereas the police officer stopping you is merely to do, for example, a Terry stop, which is a minimally invasive stop. They just need to have reasonable suspicion that any criminal activity is afoot. So it could be a misdemeanor. It could just simply be a trespass. And they could say, hey, what were you doing on that property there?
Right.
But let's move past it. And I think you're right. probably because you're the expert, but I think you're right anyway. As
Well,
far
I think
as
you'll agree once we think it through. So we look at the Georgia criminal citizens arrest statute, right? And it has that for any offense, generally presence or immediate knowledge. If there's a fleeing felon situation, then reasonable and probable suspicion is sufficient. That's the conditions that must be met in order to make a citizen's arrest. Okay, we can all agree on that very simple statute. My question then is, well, in this case, who was arrested?
Right, nobody.
Nobody was arrested. So why would they have to meet the conditions for making a citizen's arrest when they didn't, in fact, make a citizen's arrest? Nobody's liberties were infringed by arrest. So they don't have to meet the conditions for citizen's arrest for an arrest that didn't happen, that they didn't make. Now, the other reason they might need that justification of citizen's arrest is one of the justifications for using force against another person is that it was justified in the course of a citizen's arrest. But the question then becomes, well, did they use force in the course of a citizen's arrest? Because I've watched all the video and I don't see any force used by the McMichaels until they're charged by Arbery. So in one sense, it's almost better to look at this case backwards from the end to the beginning. And let's just look at the point where Arbery's charging the pickup. He turns the corner at the front of the pickup. He charges Travis McMichael, and there's this fight over the shotgun, and that's when the shots go off. Let's pretend that's all we knew. And let's pretend that the McMichaels were not doing some citizen's arrest thing. They had just come back from a hunting trip. They parked in the street. They were taking their guns out of the car so they could bring them into the house and put them in the gun safe. And suddenly Arbery charged them and attacked them for their gun. If that was all that happened, what would we say that situation was? We'd say that's straight up self-defense if they shoot Arbery, right? Okay. Now, if that conduct is lawful, that means for the McMichaels to have done something unlawful, it has to have happened before that point. Right? Does that make sense? Right. Because that conduct by itself, standing alone, is lawful. So then my question becomes, okay, if they had to have done something unlawful before that point, what was that unlawful thing they did before that point?
Yeah, and that's a good question. I think the problem I have with answering that question concretely is based on the evidence that we have, which is the cell phone video of the altercation. I'm left with a couple questions opposed to the McMichaels, which are one, so this guy, you're in the street, their truck is parked in the street, and this guy runs around the truck. I don't know that he engaged them or they engaged him at this point, because the camera goes off of the scenario. And so if they come out of the truck to engage him, I have a question of whether or not that is sufficient instigation to say that they're not entitled to use of force justification.
Well, we know for sure from the video that the truck is parked in the street, right? Because Travis McMichael was the driver. He's standing outside the vehicle. So the vehicle's not moving. Yep. Greg McMichael is in the back, the bed of the pickup truck, and they're not approaching Arbery.
Right.
Arbery is approaching them.
Yes.
They're not blocking Arbery's progress. Arbery runs past the truck unhindered. They don't block his progress. He runs past the truck and then he turns to Travis McMichael.
Sure.
He could have run straight, right?
And that's my question, is that we don't really get to see when he makes the turn, because the camera, it kind of pans off to the left. And he's out of frame for a second. So I don't know why he makes that turn. Now, maybe the answer is simply that he's turning to assault them. That is perfectly a reasonable answer there. It's just this is one of my questions, right? Like that's
we don't know why, but we know he did.
Yeah, we know he turned, but if he's turning in response to some sort of threat, I like it just as throwing out hypotheticals.
That's a fair question. But if we're going to prove that McMichael's guilty of a crime beyond a reasonable doubt, ambiguity does not serve that purpose. Ambiguity establishes reasonable doubt. Right. If we don't know what happened, if we're guessing, speculating about what happened, that's not proof beyond a reasonable doubt. That's the opposite of proof beyond a reasonable doubt.
Oh, I fully agree. And I think, of course, we're going to have facts come out at trial around that, if from no one else than the McMichaels. Plus, they will talk about what happened. They'll give testimony about.
Is that evidence likely to be favorable to the prosecution or favorable to the defense?
That evidence would almost certainly be favorable to the defense,
which makes the prosecution's already weak case even weaker. I mean, I guess what I'm trying to suggest is, as more evidence comes out, it's unlikely to be supportive of the prosecution's claim. It's more likely
I agree.
to be supportive of the defense. So I think the prosecution right now, what we know, is the strongest position they'll have, unless some surprise witness shows up, or there's the McMichaels were stupid enough to say racist things on the internet and that kind of thing is discovered. Something like that happens and blows the whole case up for them, obviously. But absent something like that, I don't see a prospect that the prosecution's case is going to get stronger moving forward than it is today.
Right. I agree. I think the only way I could see something like that happening would be if some neighbor who has not yet come forward, which is really unlikely, especially in the scenario I'm about to suggest, had some video that showed some sort of intervening act that would have caused Arbery to turn on them. And
I concur. So if there's evidence that the McMichaels actually made a threat to Arbery, if they pointed their guns at him, that's a threat, right?
Absolutely.
If they shouted at him, "Stop or we'll shoot you," that's a threat. That is assault, and with a gun, it's aggravated assault. And if it's aggravated assault, it's the basis for the felony charge against them. If there's evidence of that, that changes the whole scenario. But we don't have any evidence of that now. I watched the video, and I can't see that happening. So, and one thing to keep in mind, folks, is even the prosecution in this case does not believe the McMichaels intentionally shot Arbery, because they're not charged with an intentional use of force crime. They're charged with felony murder predicated on aggravated assault. Assault is putting another person in fear of harm. Aggravated assault, for our purposes, is putting someone in fear of deadly force harm. So even the prosecution is not saying they intentionally used force against him. If they were saying that, it would be aggravated battery, or it would be murder. So they're not saying that. Even the prosecution doesn't believe they can prove the McMichaels deliberately shot Arbery. That's why it's an aggravated assault charge. That's the predicate for the felony murder charge. So they either think the actual shooting itself was lawful self-defense, because at that point Arbery was grappling for the gun, or it could potentially be accidental shooting, because in the course of fighting over the shotgun discharges. It wasn't an intentional discharge of the gun.
So they must be running on a theory of the case. And this is just to clarify for the audience. When I say a theory of the case, I'm not saying a theory of the case that's supported by present facts. I'm saying that this is the theory that the prosecution is hoping to find the facts to support as they go forward. But they must be running on a theory of the case that some sort of assault or aggravated assault with involving the guns happened, causing him to stop, right? Like that's the theory. But yeah, I agree. They're very unlikely to find that new evidence. And the reason I think we know they're very unlikely to do that is because anybody with a cell phone footage from another angle, which would have shown the alleged assault, would be holding $50,000 check in their phone from any.
No, if they had that evidence, we would know.
Yeah, the news companies would pay you immediately for that kind of footage. And you would get to do all sorts of interviews. So,
and by the way, if anybody's aware of evidence, video, photographs, testimony of anybody who's prepared to say that the McMichaels actually made an explicit threat or brandishing of their weapons at Arbery, I'm the first person who wants to know, because that completely changes the character of the case. But absent that kind of explicit threat, there is no assault. And if there is no assault, there's no aggravated assault. And if there's no aggravated assault, there's no predicate for the felony murder charge. There is no case.
Yeah, I was shocked when I found out that the hammer, because that's been a big part of the narrative, right? He was walking around the neighborhood with a hammer, for example. That was. I
don't know if that's true, by the way, but we can certainly discuss the possibility.
Well, even if he had the hammer, maybe he stole it from the construction site. None of that is factually supported, but it's an allegation that's out there. So he's got this hammer. That alleged hammer, whatever the object is dropped prior to the altercation as well. So it doesn't support the idea if someone's pointing a gun at me and I'm going to assault them in response, or I'm going to defend myself, if I'm Arbery in this case, I'm going to bring the hammer, right? Like, but he doesn't attack them with a hammer. It's kind of an interesting.
It's fun to speculate about what might have motivated Arbery, but it doesn't really matter in terms of the McMichael's guilt or not guilt, because what matters is their reasonable perception of events. Right. So what's actually motivating Arbery, what's happening inside his head, that doesn't really matter. What matters is how he presents to the McMichaels, how they are perceiving his conduct. Now, the hammer could matter in the sense that if he had the hammer, even if he dropped it along the way. So if he drops it, it's no longer, for example, a weapon that could be used against a McMichael. So it's not relevant for that purpose, but it could be relevant for affirming or corroborating their perception that he committed a felony burglary in the first place, right? If that was property from the site. But I have to be honest, that only matters if they actually threatened him with force. If they threatened him with force, he better have committed that felony burglary. Then the citizens' law statute really matters, because they need a justification for that threat of force. But if they never explicitly threatened him, they don't need the citizens' arrest justification, because they didn't do anything that was unlawful. And if you didn't do anything that was unlawful, you didn't commit assault, didn't commit aggravated assault, didn't commit felony murder predicated on aggravated assault.
Right. And so that's it is interesting that, see, here I was kind of prepping for the show, and I was going to ask you all these cute trap questions about the citizens arrest law and trying to pick apart the argument a little bit. But you're right, there is no citizens arrest that was affected. And citizens arrest would be a
done this before.
No. But citizens arrest law, it's actually, I have a question about that. And I guess this is part of the show prep is a citizen's arrest law covered by the Justification statute? Because it doesn't, it doesn't cite the citizen's arrest law, and it doesn't say citizen's arrest. It just says a lawful arrest. So I guess it's under that umbrella of lawful arrest.
Citizen's arrest is what defines a lawful arrest within the scope of a private citizen making an arrest. So that would be
right.
I don't see another interpretation of that. That's subparagraph 4 in the Justification statute. I don't see another interpretation of that. So if it says it's justified if it's a lawful arrest, then you have to ask, well, what constitutes a lawful arrest? And well, that's the citizen's arrest statute. So
sure. And then, but the counter argument, and this is again theory crafting, I don't think this is a strong theory or counter argument to it. So please, I'm not presenting it in that way. But I think if the prosecution is going to try and run this, and they're going to attack that citizen's arrest angle, they're going to bring up the McPetrie versus State case from 2003, which the specific line is, let's see.
Make sure you read the case and not the media reporting on the case, because
no.
Things. Okay.
I haven't seen the media talk about this case. I'm only assuming that they are. Just because it's recent and it involved the citizen's arrest. And the line from the case is that basically the defendant is not permitted, the law is not so broad as to permit the defendant to mete out justice as he sees fit. That's the log line of the case. But I don't think that really applies in this case. In that one,
it would apply if the McMichaels had used especially deadly force against Arbery for the purpose of the citizen's arrest. But that's not what they're saying. In fact, the McMichaels, by the way, are saying their intent was not to make a citizen's arrest. Their intent was simply to ask Arbery questions about his conduct in the building to determine whether or not a citizen's arrest would be warranted. So they're saying explicitly, they say this in the incident report to the police in the immediate aftermath of the shooting. We called out to him, stop, we want to ask you some questions, or stop, we want to talk to you, whatever the particular language might be. Asking someone to stop so you can ask them questions, they can blow you off. They don't have to pay any attention to you at all. They can say piss. But that's not an arrest. An arrest is holding someone in the context of citizen's arrest. It's holding someone until the police come to formally take them into custody.
Now, as a counterpoint to that, though, if the McMichaels, Mr. McMichaels has a shotgun in his hand when he says, stop, we'd like to ask you some questions, doesn't that potentially stray into the question of an assault? I mean, that would, I can
It would.
certainly see that
It
being
would
ruled.
if there was something more than the mere possession. So the mere possession in your hands of a shotgun under Georgia law is perfectly lawful. It's an open carry state. You're allowed to have a long gun in your hands. If they do more than just have it in their hands, if they gesture, if they brandish it at Arbery, that changes the dynamics. Then you need more. But there's no evidence that they did that. It's not in the video. They're not saying they did that. There's no witness who says they did that. And if all they're doing is standing there with, because they'll say, we were holding the gun because we knew this guy was a bad cat because my dad has investigated him for a gun crime before. We wanted to be prepared to defend ourselves if he attacked us. And by the way, guess what? He attacked him, right?
Yeah.
So from their perspective, it was the right call to be armed.
Sure.
So unless they did something beyond simply holding the gun, which is perfectly lawful under Georgia law, it's not unlawful conduct that can be itself the predicate for an assault charge or other criminal allegation. It's lawful conduct. Having the gun is lawful conduct. If they point it, brandish it, threaten with it, that changes the dynamic. But as far as I can tell, there's literally zero evidence that they did that. Doesn't mean they didn't do it, but there's zero evidence of it. And the prosecution needs that evidence to push their theory of the case.
I agree, and that's often the distinction in these types of cases, in really any criminal case, it's not so much the adage from the movies is it's not what happened, it's what you can prove, but it really is, especially in criminal cases, what you can prove. Because I would fully expect that the prosecutor is going to try and instill, just based on what we've been talking about, instill in the mind of the jury that they brandished the gun or they used it in some sort of implied assault. And the defense's job will be to merely point out, you can't support that. You cannot say that that happened. You have no foundation for it at all. Right. But I think that's...
So I expect we'll hear that kind of language.
Yeah.
I saw this a lot in the Zimmerman case. If you watch the Zimmerman case, especially the opening statements, the prosecution got up there and they engaged in a lot of histrionics. A lot of shouting, a lot of anger, a lot of outrage, almost zero facts or law in their opening statement. The defense got up there, talked about the law, talked about the evidence, talked about the standard of proof, what it means to prove someone guilty beyond a reasonable doubt. Very technical opening statement for the defense, histrionics from the prosecution. When they got to closing statements, it was exactly the same thing. The defense stepped through the evidence, stepped through the law, stepped through the burden of proof. And the prosecution stood up there and yelled about things like the fact that Zimmerman not only had a gun on his person, he had a gun with a round in the chamber in the ready-to-fire condition.
Oh, my goodness.
That was a legally relevant point, as if everyone who carries a gun for personal protection doesn't have a round in the chamber, as if every bailiff in that courtroom didn't have a round in the chamber of their service pistols, because they didn't have anything to argue on the merits of the case. So I think what we'll see in this case is much the same. I think the prosecution will get up, they'll yell a lot, they'll shout a lot, there'll be a lot of outrage. They'll talk about what a great guy Arbery was, what a terrible tragedy this is for his family, and they'll be very light on talking about the actual facts and law, and they'll hope that the emotion of it will carry them through to a conviction. And by the way, it might, folks. So for those of you who don't know, every case I work on, I tell the clients, especially if they're offered a plea deal, because normal law-abiding people don't want to take a plea deal because they think what they did was appropriate self-defense. If we put you in front of a jury, I don't care if you're the most innocent person I've ever worked for, there's a 10% chance you're going to prison. There's a 10% chance you're getting convicted. And if it's a racially charged case like this one, just multiply that by 4. There's a 40% chance you're going to get convicted, even if you're 100% innocent. And that's the dynamic facing the McMichaels. So, and the prosecution knows this too, of course. So the prosecution knows, hey, even if we have a dog of a case, if we go in there and shout enough and create enough emotion among the jury, we got a 40% chance of a conviction. That's not bad. We'll take that shot, especially since for the prosecutor, especially the prosecutor just appointed to this case, the 4th one, because all the other ones didn't want anything to do with this case. They got rid of this case as soon as they could wash their hands of it. This prosecutor, this is a career-making case for her. She may run for governor someday on this case, and it doesn't matter if she gets a conviction or not. If she gets a conviction, great. She put them in jail for the rest of their lives. If she doesn't get a conviction, she fought the good fight. right, did her best to try to get these guys convicted. She's a hero either way. So just like with Angela Corey in the Zimmerman case, what matters for her is not necessarily a conviction. It's a win for her whether she gets a conviction or not. And if that's the dynamic, if it's a win either way, and she's got a 40% chance of a conviction, even with a dog of a case, if you're a political animal, you'd be crazy not to take that opportunity.
Oh, absolutely. Absolutely. And going off of, her campaign can be, we have to change these backwards citizens arrest laws, even if they have nothing to do with the ultimate conviction. They've been talked about so much by now. We've got to change this and not let this happen again. This is tearing our community apart. This was,
by the way, I think that's perfectly legitimate. I think if people want to have a public policy debate about changing Georgia law, I think any criminal citizens arrest statute that's from the 1930s, since it was last revised, hey guys, maybe it's time to take a look again, because standards have changed. We have modern police forces now throughout in every municipality. I mean, maybe we don't need such a broad citizens arrest law anymore. Maybe in an era of concealed carry, of modern social dynamics, that law is no longer appropriate. I think that's a perfectly reasonable position to take, but that's a future law. That's not the law that existed when these guys acted.
Right, absolutely. I think on the I don't know if I have any other questions about the Arbery case. I think you're right in your some summary of it. I was going to say summation, but summary of it is that it boils down ultimately at this point to a self-defense question. Did Ahmaud Arbery put the McMichaels in reasonable fear of imminent death or serious bodily injury, which I assume is the standard in Georgia?
Yeah, and there's really no question about that. Once he charges, he grabs the shotgun and they're fighting over the shotgun. That's a deadly defensive force situation every day of the week and twice on Sunday.
Anyone touches a gun that's in your possession, that immediately puts you in fear. Even if they reach for it, that puts you in fear.
Unless, of course, you're acting unlawfully. But again, there's no evidence of unlawful conduct by the McMichaels prior to that point. And after that point, it's just self-defense if there wasn't unlawful conduct prior.
So did the McMichaels end up? You mentioned that there's an investigator report that they spoke to police at least somewhat.
The father did.
Was he fully interrogated?
Here's another. No, it was not. It was very superficial on the scene discussion. It was caught on body camera. So the officer who wrote up the report said my body camera was on. So I'd love to get that video, because obviously that'll show like demeanor. It'll be a more accurate representation of what was said. Than when you tell a cop something. Like any of us, we've all played the game telephone, right? Where circle people whisper something and it comes out completely different than it went in. Well, when you tell a cop something, the same thing happens inside his head. You say words, he hears words, they get processed in his brain, they travel down to his fingers, and he writes stuff on a pad. But what's written on the pad, and this is without ill intention on the part of the officer, what's written on the pad may not be representative of what you actually said, right? He may have misheard or misinterpreted or kind of summarized what you said in a very abbreviated way in his pad. And when he looks at it a year later at trial, it looks completely different than it did at the time, right? When he refreshed his recollection on the witness stand.
I can give an example of this. I got a speeding ticket long before I was an attorney. And the cop pulled me over and he says, "You know why I pulled you over?" Which you should never answer anyway. But I said, "I bet you think I was speeding." And what he wrote down on the back of his pad was, perpetrator said I was speeding, which is true. I actually did say those words, but I was saying them sarcastically. There was no way I could have actually, my car was a junk pile and it couldn't go as fast as he said, but that was beside the point. It didn't matter. Trying to prove that several months later at a trial on a traffic stop, the police officer's going to say, "Look, all I got was what I wrote down at the time. That's going to be better than any recollection I have now." And did he write? Right. Did he write it down at the time? No, of course not. So yeah, it is interesting that they do have that interview recorded. My understanding and experience is that typically the police don't record those things. They like to use their notes. Or if they do record those things.
Yeah, well, the notes are more, how can I put it? The notes are more malleable
yes,
than a recording. But in these days of body cams, they go on, basically automatically on certain circumstances. So if we can get the video, that would be great. But the only person who spoke to the investigative officers, just a patrol officer really at the scene, who contributed to the incident report was the father,
Sure.
Greg McMichaels. And this is an interesting part too of the charge. So if you look at the arrest warrants, and the Georgia Bureau of Investigation is very funny. They give me some documents I ask for, and they don't give me other documents, and I can't tell why. But they did give me the arrest warrants, and it's only the son, Travis McMichael, who's charged with the aggravated assault, which is the predicate for felony murder. His father's charged with aiding and abetting aggravated assault, which is the predicate for felony murder. So the prosecution is not even saying that the father even committed assault.
And the father's the one who shot, right?
No, the father's in the back of the pickup truck.
Oh, okay, my misunderstanding. I thought the father.
What that tells us is that the only use of force that happened was by the son, was by Travis, by the person with the shotgun. So I heard earlier reporting that the father had a .357 revolver and he fired shots. That never happened. If that happened, they would have charged the father with assault, not aiding and abetting assault. Right. So they're basically just saying the father assisted the son in what the son did as an assault. The prosecution is claiming is an assault. So they're not even claiming the father even put fear into Arbery. They're just saying he assisted the son in putting fear into Arbery, which constitutes the assault and the aggravated assault and the felony murder. So if the only person who used force was the son, and the only shots that were fired were 3, and all 3 shots were fired while Arbery was fighting for the weapon, had his hands on the shotgun for every single one of those rounds, man, that's a pretty good scenario for arguing every shot was in fact accidental and or caused by Arbery, rather than intentionally fired by Travis McMichael.
Right. Yeah, I think so. Because in the video I saw, now all of the videos I saw, because everybody does this, which is really frustrating. They stop when the first shot is fired, and they don't show the aftermath, because apparently you can see every second up until someone dies, but seeing them actually die ruins everybody's day, or something.
If you'd like, I have the whole video, so I'm happy to share it with you. I mean, I can't do it live here, but
yeah, no, I would love to see the remainder of the video. So if you could email that to me, I'd be really appreciative. But I never saw the father intervene in any meaningful way either. The scuffle seemed to happen between the son and Arbery, but I don't know if he gets out of the truck bed during that scuffle.
No, he doesn't. The whole thing is about 3 seconds. I mean, it happens very quickly.
Yeah, I didn't think so, but just because the videos I've seen have all stopped when that first shot is fired, I didn't know if anything happened afterwards. But no, I mean, I think that summarizes it very well. You've convinced me. I don't think the citizen's arrest is going to matter unless they can somehow pin some assaultive behavior that is not currently in evidence upon the McMichaels.
If they can do that, then the McMichaels have to rely on the citizen's arrest statute, and they better hope that they can convince a jury that they in fact had reasonable and probable suspicion, whatever that means.
Right.
And of course, the prosecution is going to argue it's a much higher threshold than what the defense would like the jury to think.
And I would assume the prosecution would make a public policy argument that this law is outdated and needs to be narrowly interpreted and not allowed for this sort of thing where they track them down.
I don't know if that helps them in this prosecution. I think that's a perfectly legitimate public policy decision. But if I were on the defense, I would beat the crap out of that. I mean, everybody. Every member of the jury, your sons, your daughters are entitled to be judged not by the law as we would like it to be in hindsight, but by the law as it actually exists. Would you want your son brought onto trial based on some hypothetical future law that the state of Georgia might pass someday? That's not justice.
No.
Right. And you can hate the laws that currently exist, but the solution to hating the law that currently exists is to revise the law moving forward. You can't apply it retroactively. So I'm sure I think you're right. I think the prosecution, if I were the prosecution, I'd make that argument, public policy. Maybe technically it was allowed, but really this was an offense to our sensibilities and blah, 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 the kind of stuff the prosecutors talk about. But if he's got competent legal defense, and by the way, that's going to be a huge factor here. I just saw some video of he finally got a couple of attorneys, it looks like. I saw a few seconds of them giving a media briefing. They seem to be fine, but you never really know what attorneys are like until they're in the arena. And sometimes they're really great, like they were in the Zimmerman case. And most of your commenters will probably be familiar with the Michael Rekieta case, which was the handicapped parking spot case.
Yep.
And we can believe that Rekieta should have been acquitted or was appropriately found guilty. That's not the point I want to bring up. I would just mention that his legal defense team sucked. They were awful. And I consider that an injustice. I think if someone's going to be sent to prison for the rest of their lives, it should be after they've had competent, capable legal representation, and not because their legal counsel sucked and the prosecution just walked all over them. So I fine with Drake going to prison for the rest of his life if he had competent counsel. But those people showed up like they were effing hungover. I mean, it was pathetic to watch. And it happens, they're well-respected attorneys in the jurisdiction, but they didn't bring their A game to that trial.
No, they didn't. I covered the aftermath of that trial in a couple long videos. I think Drejka really sunk himself in his interview with the police.
Oh yeah, that was catastrophic.
And the fact that this is, and I think this is a problem and a caution to right-leaning people who have a favorable disposition towards police, and especially I see it in a lot of concealed carry holders that I know. They believe that the investigator is buddy, and they identify on the fact that you guys both have guns. That is not a correct approach to take when you're going to be risking the rest of your life in prison. And I thought Drejka kind of manifested those behaviors in that interview, where he's kind of talking with what we call tactical sort of language, and
talking about the Truer drill and 21 feet, and
right.
Well, he didn't know what he was talking about, so that didn't help him.
Yeah,
I mean, he got it wrong. He had a very childlike understanding of those concepts. But listen, folks, I mean, just look at the news today and we see, police are just human beings, okay? They're not superheroes there to defend us. They have jobs, they have pensions, they have families, they have mortgages. And when you see cops in this era of COVID going out and arresting people for not wearing a mask properly, like I saw a video of today, and you think to yourself, oh my God, they look like stormtroopers. Well, they've been told they're going to lose their job if they don't do that. They're not doing that because they want to arrest a woman and separate her from her child because she's wearing a mask crooked. Their boss, who's a political creature, the boss of the police is a politician. A police chief is a politician. Whoever's overseeing them is a politician, is telling them, you will lose your job if you don't do this. And they're just normal people, and there's no fallback position. If they get fired, what are they going to do? Sell insurance? I mean, sorry for those of you who sell insurance. I don't mean in a derogatory sense, but I mean anyone who's been a cop for 10 years, they can't just switch gears like that.
No,
they're counting on hacking out the next 10 years so they can get that pension. So if they're investigating you, they're interviewing you, and they're acting like your best buddy in the world, they may be. Right? They may feel like, oh, this looks like self-defense to me. But if their boss comes to them and says, listen, you got to push this guy harder, you got to get him to say these things, they're going to try to get you to say those things. They can't make you say those things. But if they can lead you down the path and you end up saying those things, that's not their fault. That's your fault.
Right. And that's kind of where I wanted to transition the discussion to go. I mean, I think Ahmaud Arbery it's an interesting case, but only insofar as the media makes these things about a social story. And my caution to everybody is the social story is never the legal story. It is never the legal story. There's all kinds of agenda involved in it on both sides. Absolutely. I mean, I think the reason the citizen's arrest, and maybe I'm wrong on how this occurred, but my guess is the reason the citizen's arrest thing came up is because it was people sympathetic to the McMichaels were saying, no, they are justified in following him through this neighborhood, even though shockingly, you can actually follow people around for a little bit. That's not illegal if they're on a public roadway or whatever. You can do that. At some point, they may turn around and ask you to stop, and then we have a different question. But until they do, you can follow people around.
If you're not doing it for unlawful purpose,
right?
If you're doing it, for example, you have reason to be suspicious that they might have committed a crime. That's not following them is not a crime, folks. Asking them a question is not a crime. There's no particular justification needed for that. Now, if you're doing it for unlawful purpose, well, that changes everything. Then it becomes stalking or aggravated stalking. Then it becomes a criminal act. But if you see a stranger come out of your neighbor's home and your neighbor's on vacation and you're like, well, I've never seen that person before. I know my stranger pretty well. They would have told me if they were expecting someone to come in. I think I'm going to follow that car a little bit, call the police, call 911, and, make sure nothing is going awry here, which is basically what the McMichaels did here. The McMichaels called 911. And frankly, this is a dynamic of this case that's very similar to the Zimmerman case, right? Zimmerman was on the phone with 911 right up to seconds before his confrontation with Trayvon Martin. And we're supposed to believe that the person who's going to be, some kind of racist murderer of somebody for having Skittles in a hoodie, before they do that, they spend 5 minutes on the phone with 911 asking for officers to be sent to the scene. I mean, it stretches credulity. I mean, you wouldn't do that. If you were a racist murderer, you just commit the act of murder. You certainly don't want the police coming to the scene. And the same is true here. The McMichaels called the police, send police here. You don't do that if you're going to commit a murder. You don't want the police there if you're going to commit a murder.
Well, now that I've seen two people do that while committing a murder, have you considered you're just bad at covering up murders? I'm kidding, of course. On Your Knees B says, for Andrew, there was a case out of Florida, I think, where a woman was denied a stand your ground defense because she left the room to get her weapon to protect herself from her boyfriend/spouse.
Yeah. That's Marissa Alexander.
Oh, was that the case you referenced earlier? And are there any extra thoughts on it?
Yeah. Okay. So first of all, I hate the state of Florida. Apologies to those of you from Florida. But Florida adopted two completely different statutes at the same time. And because they did that, the same terminology, the same phrase is used for both of these statutes, even though they're completely different, and it creates unending confusion. They adopted a stand your ground statute, and they adopted a self-defense immunity statute. The stand your ground statute said before you would have had a duty to retreat, before you could defend yourself, we're taking that duty away. You no longer have a legal duty to retreat, even if it would be safely possible before you can defend yourself. It redefined self-defense. It changed the scope of the conduct that qualified as self-defense. Before, if you didn't retreat, you lost self-defense. Now, if you didn't retreat, you didn't lose self-defense. So it basically broadened the conduct that would qualify as self-defense, redefined self-defense. Self-defense immunity is completely different. It doesn't care about the definition of self-defense. All it says is if your conduct was self-defense, however it may be defined elsewhere, you're eligible for immunity from criminal prosecution and civil suit. So one is stand your ground. You don't have to retreat. The other is self-defense immunity. And what the best way to think about self-defense immunity is it's kind of an accelerated way of determining self-defense. So traditionally, if you're charged with a crime of use of force and you want to raise the legal defense of self-defense, you have to do that at trial. And trials are catastrophically costly and time-consuming. So the Florida legislature said, well, if it's really clearly a case of self-defense, we ought to provide a pre-trial mechanism for determining those cases of self-defense. So the really clear cases of self-defense don't have to go to trial. Instead of a $100,000 or multi-$100,000 trial, you can have a $5,000 or $10,000 pretrial hearing, present your evidence, the prosecution gets to make their case, and the judge makes a decision on whether or not it's self-defense. And if he decides it was self-defense, you're immunized against prosecution and against civil suit.
And
so that is properly understood. And I know everybody, including the Florida courts and Florida lawyers, call that a stand your ground hearing. It's not a stand your ground hearing. It's a self-defense immunity hearing. It's a hearing to determine whether or not you qualify for immunity. You don't have to qualify for stand your ground. Stand your ground is just the law. It applies to everybody. Immunity is something you have to qualify for.
Well, and that's that was highlighted to me by the Drejka case. Because the Pinellas County sheriff, who I believe is notoriously anti Second Amendment, so to speak, we'll say anti-gun, he said that he could not arrest Drejka because of the stand your ground immunity, which was nonsensical to anybody who knew anything about it. Because
pure political theater.
Right. It's like, no. He gets that's a defense raised at a pretrial hearing that has nothing to do with whether or not you can effect arrest. So that's.
And by the way, the whole Branca case was very ambiguous. This was not like the Zimmerman case. This was not where the evidence was overwhelming. If you looked at the obvious evidence, I'm very critical in examining these kinds of cases. And when I looked at the Draca case, to me, it was like, well, it could go either way.
Yeah,
I mean, it was really a close call.
I was satisfied with the conviction of Drejka. I did think his attorney team was trash, mainly because of stuff they were running, like a social media campaign and stuff, and they were like they got called out for this at the sentencing hearing too. They just did not advise him on how to conduct himself during the trial very well, in my opinion. He was trying to run like this media blitz. It's like, buddy, you're right now trying to not go to prison for the rest of your life. That's what you should be focused on.
That's the mission, right?
But when I go back and I watch the video and then I listen to that police interview, I think they've got the right decision on that one. But it was certainly close. It was a lot closer than Darren Wilson, than Zimmerman, obviously. And it looks like that's even closer than this case. If the McMichaels have not made any of those sort of statements to police, then I think the police are going to be, or the prosecutors are going to really have a hard time getting this case off the ground.
I honestly don't think there's any merit to this prosecution at all. I think the original district attorney who wrote that 3-page letter, Barnhill, made the right call on this case. I don't think any new evidence has really been developed that he wasn't aware of at the time. I mean, we're learning it because it's dribbling out, but he had all this evidence at the time. Yeah. So I don't think they have any case on the merits. But another thing to keep in mind, I saw someone in the comments mentioned, I think they said, I'll paraphrase, but if the jury's racist, it doesn't matter. He's going to get convicted anyway. Folks, that's a reality. You know, you can get convicted even if the prosecution does not have a meritorious case. That's why people ask me, well, Andrew, would you advise your clients to make a citizen's arrest? Hell no. I wouldn't advise anybody to make a citizen's arrest. I think it's crazy. I think the risks are unbelievable and there's no upside. By the way, there's no upside, especially in this era of bail reform where someone gets arrested and they're out before the cop has done the paperwork on their own recognizance, almost regardless of what offense they committed. So you do a citizen's arrest and you're the hero, and you're still talking to the cops doing the incident report, and the guy's back on the street. So what did you just accomplish? The whole thing is crazy, but and you're running the risk that it's going to end up being this kind of racially charged case where there's powerful political drivers to making you pay as high a price as possible. Even if you're acquitted, they will destroy you in the process of the case.
Right, because a lot of these, like you said, there's a big difference between a $30,000 legal defense, and most people, your average American doesn't have a $30,000 savings account that they can just dump into a legal defense.
That's $300,000.
Right.
Which I would want.
Right. So what you're talking about is mortgaging or selling your house. You're talking about selling your cars. One of the cases I had a mild assist on, the defendants were having trouble paying the lead attorney on it, and he's like, "You've got a truck, sell it." It was like, well, that's the way they get to work. That was all they had. But at the same time,
if you're looking at the rest of your life in a cage with really unpleasant people, I can assure you, you will sell everything to try to prevent that from happening. And you can, by the way, you can spend all that money, still get convicted, still go to prison, and now your family's got nothing. So before you engage in conduct that puts you at risk of that kind of legal and financial peril, I urge people to think, well, what's worth that? What's worth that? If you get sentenced to 20 years in prison and you have to spend every penny ending up with that result, right? You got convicted anyway, despite selling everything. What is worth, and the last day of that 20th year, could you look in the mirror and tell yourself it was the right thing to press that trigger, and I would do it again today, even knowing I would spend 20 years in jail? Because there are circumstances that meet that standard, right? Personally, I'd rather be alive in prison than dead outside of prison. I'd rather my wife, my children were alive, even if it meant I had to go to prison for 20 years. But once you get past that, what's worth that risk? Not your property, not your car, a stranger? I don't know. I mean, each of us will draw that line in a different place. So I don't try to tell people where to draw that line. I do urge people to make that decision ahead of time now, think it through now, and do it in an informed way so you know what those risks actually are.
Yeah, and it's also, I think it also is a tribute to Florida, as much of a dumpster fire as that state can be. It is a tribute to the self-defense immunity law, and that pretrial hearing is a massive boon to the criminal justice system.
Absolutely. More important than standing your ground, by the way.
I was going to ask if you knew the evidentiary standard or the degree of proof that was required at that hearing. Is it clear and convincing evidence, or is it preponderance of the evidence?
Currently, so it keeps changing in Florida. So, when the states pass these self-defense immunity laws, of course, it's the legislature that creates the law, right? So they create the law, the governor signs the law, and they say, basically, in effect, if the use of force was lawful self-defense, you have immunity from criminal prosecution and civil suit. But they never set out the standards of what that should be. Who determines? Should it be a pretrial hearing or not? What's the standard of proof? Who bears the burden? They never say that. And Florida went through a process of like 15 years of multiple state Supreme Court decisions where they hammered all that out because all the district courts were coming up with different standards, and it was an absolute insane mess. And they finally arrived at a standard that they held for many years, where they said, all right, the burden's on, if a defendant raises a self-defense immunity claim, so they demand a self-defense immunity hearing. At that hearing, the burden is on the state to disprove self-defense by a preponderance of the evidence. So just a sheer majority of the evidence. But what happened is every court was denying immunity, every single one.
Okay.
Because as far as the hearing judge is concerned, he's like, well, why should I take the heat of letting someone go, right? Let it go to trial. Let the jury take the heat if they're going to let someone go. And the legislature got fed up with that because it effectively neutered the whole purpose of the immunity statute. So the legislature finally passed a law that said, no, we are going to define what the legal standard is. The standard is the prosecution has the burden by clear and convincing evidence. Now, nobody really knows what clear and convincing evidence is. I mean, it's somewhere between a preponderance and beyond a reasonable doubt. We know that, but that's a huge chasm.
Yeah.
But they're hoping that will lead the courts to begin granting immunity more often than they were doing in the past. But the current standard in Florida is if you can meet, I don't want to get too technical, but if you can meet your burden of production, you have a credible claim of self-defense, you demand your self-defense immunity hearing. At that hearing in Florida, the state has the burden of disproving your claim of self-defense by clear and convincing evidence. If they can do that, you're denied immunity. If they can't do that, you're supposed to be granted immunity.
So that's really interesting. I feel like the burden should be on the movement.
But keep in mind, at trial, the burden's on the state to disprove self-defense beyond a reasonable doubt, which is a much higher standard. So if they can't disprove self-defense by clear and convincing evidence, they'll never be able to do it beyond a reasonable doubt. So if they can't meet that lesser threshold, why should they be entitled to take you to trial?
Right, I agree. I just feel like the burden should be on the movement because I feel philosophically, if a defendant can prove by preponderance of the evidence that they had a right to self-defense, then there's also no way that the prosecution could show beyond any reasonable doubt. So
and that's the more common standard. So most states that have self-defense immunity laws, that's the standard. Who bears the burden varies, but frankly, if we're talking preponderance of the evidence, it hardly matters who bears the burden because it's that 50%. So it's wherever you end up. But for most states, self-defense immunity, for most states that have self-defense immunity, because not all do, about half the states do, the standard is preponderance of the evidence.
Sure. Okay, well, that was a good question. Thank you. Slipknot Draken says, you never trust a cop, especially a Georgia cop. I'm from Griffin and live in the complex of the sheriff's deputy whose wife, quote, attempted suicide. I'm not familiar with that case at all, but I will lightly.
It shouldn't be a matter of trust. I mean, don't think of it in terms of trust. Just think of it as you walk into a room and there's a glass of liquid on that table. You don't have to trust it, but you're not going to drink it. You don't know what it is. You know, it's not. You don't have to hate cops. You don't have to think cops are out to get you. You don't know. Right. So don't make any assumptions that they're favorably disposed or disfavorably disposed. Just conduct yourself in such a way that you're not exposed to risk if it turns out they're disfavorably disposed.
Absolutely. Perception Check says, Andrew, Never apologize to Florida. Also, Andrew is a great guest, and I'd love to see him on a big brain panel. Well, that'd be up to him. I do a show with a couple other lawyers where we drink sufficient amounts of whiskey to really talk about various legal issues with no expectation of legal advice, just off the cuff discussion. But
okay,
I'll invite you, and you're certainly welcome to come or deny at any time.
Well, as people might have guessed by my demeanor, all I basically do is talk about this stuff all the time, endlessly. So I'm happy to do it. It's fine.
Well, so my next question then is getting back to just sort of general practice. And I asked you about this before the show. What advice do you give to someone who's involved in this? Like you have the magic of foresight. You're going to be involved in a self-defense shooting.
Sure.
You fire your weapon. Person falls to the ground, either dead or not. Doesn't really matter at this point. What do you do next? What are the steps?
Yeah, so it's a great question, and frankly, my views on this have evolved over the years. So I teach, for those who don't know, I teach a full day law self-defense class. We call it our level 1 class. It's 7 or 8 hours long. We do it because of COVID. I've taught it live all over the country to thousands of students. Now we do it mostly as a webinar because of COVID and other reasons. But we spend almost a full hour of that class talking about interacting with the police in the aftermath of a use of force event. And so this is what we're talking about. And I think there's kind of an optimal, quote unquote, professional approach to this that I used to teach as the most desirable option. And over the years, I've gradually moved away from that. I still teach it as something for people to consider, but I've increasingly discouraged people from considering that primary option. And I call that option the say little approach. So don't say a lot, but say certain very specific, limited things. And those things primarily have to do with identifying for responding officers exculpatory evidence and witnesses. Because for most good guy cases of self-defense, more evidence is good for us. If there's video, if there's witnesses, if we acted legitimately within the bounds of self-defense, we want that evidence found. Good guy cases of self-defense, folks, don't tend to get into trouble because there's too much evidence in the case. They tend to get into trouble when there's too little evidence in the case.
Right.
And the claim of self-defense looks ambiguous or fabricated. So ideally, say you're attacked by some guy with a knife and you shoot him and the knife flies under a truck. Are you not going to tell the responding officers the guy's knife is under the truck? Because you need that knife in evidence. If that knife is not in evidence, for all anybody knows, you're fabricating the story about the knife. So that's the kind of thing we used to teach. And if you see witnesses, if there were witnesses there, 20 minutes later, when there's 5 patrol cars, there's going to be 100 witnesses, right? People will come out of bars and apartments, and the cops aren't going to know which ones were there at the time the event actually occurred. And you want to get their statements. You don't want those people to disappear.
Right.
So I used to teach that as kind of the say little approach, the optimal approach. But here's the problem. About 5 years ago, as part of my live classes, we purchased a very high-end self-defense simulator system, a $20,000 simulator system that would basically show a video movie of a potential aggressor, and you had to use an infrared pistol, a fake gun, or something else. And you had to make use of force decisions. So you had to decide whether or not you were going to draw your weapon, shoot the assailant, and so forth. Right. And this is a totally artificial environment, right? It's a video on a screen, and typically in a motel conference room. There's no danger. You can't get hurt. You'd have to trip over a chair to get hurt. There's no danger. And the video only lasts 30 seconds, 60 seconds. They're relatively short. And after that 60 seconds, after the person had resolved the video scenario however they thought best, we would have them turn their back to the screen and tell the rest of the class what they saw, what they did, and why they did it. What was their legal justification for what they did? And man, they could not do it. They could not remember what they saw, or if I suggested things like, say the assailant was not wearing a hat, I would say, well, what color was the guy's hat? And they'd go, blue. I mean, they would make stuff up because they thought it was expected. They couldn't remember what they saw. They couldn't remember what they did, or if they did remember what they did, they couldn't remember the timing properly. So it was very common for students, the moment the video started, they would draw the infrared gun from the holster. And then we'd ask them, well, when did you draw the gun? Oh, I didn't draw the gun until I saw the knife. No, that's not what happened. You drew the gun the instant that video started. They're not lying, but the way the brain captures and stores and recalls information under even that slight artificial stress is completely different than the normal experience. And they couldn't explain why they did what they did, of course. If you can't remember what you did, you can't explain why you did it. And watching hundreds of students go through that process in a typically artificial stress environment, it made me think that, you know what? That say little approach, that professional approach, that optimized approach, I bet not 1% of these people could pull that off if they'd actually just survived a life-threatening attack. And if you can't pull that off, if you can't limit what you're saying to those specific things, man, you better not say anything.
Right.
Because if your choices are saying nothing or start blabbing away, you better say nothing, because if you start blabbing away, you will bury yourself exactly the way Michael Drake buried himself.
Yeah, I agree. My thoughts on the police are, you just pulled a trigger. Even if you just go to a range and pull a trigger, there's exhilaration, there's adrenaline, there's all sorts of cool things. That's why we like shooting guns. It's fun, it's interesting, it provides a very visceral reaction in you, and that is caused by a bunch of chemicals flooding into our system. So that alone, and that's ignoring all of the danger, the fight or flight, and all of that stuff. That messes with your ability to recount things. So I'm always of the opinion, you don't say anything, you get an attorney, even if it's merely for the delay in having your attorney show up. It provides you the opportunity to start calming down, and then it gives you a chance for someone to help you frame the discussion that's about to occur.
Right. There's a reason most police officers involved in the use of force event are permitted 24, 48, 72 hours before they have to give a formal statement. And it's to allow all that brain chemistry to settle down so that when they give a statement, it's at least internally consistent and coherent. Because if you took statements, it's like a laboratory test. If you took statements at an hour and 6 hours and 12 hours and 24 hours from a perfectly honest defender in a crime, you'd get different statements. You'd get different details. You'd get conflicting details. That's just the nature of how that works. And if nothing sets a cop's alarm bells off more than if he gets two statements from a suspect and they're different. If they conflict with each other, now that guy's lying, right? That's the assumption. And with a prosecutor looks at it, of course, much later in the process, but when a prosecutor looks at that investigative file, what he's looking at is, does this look like a case I can win? You can think of prosecutors as kind of being professionally graded on their win-loss record. And most of them have conviction rates at trial of 90% or better, which isn't just because they're great lawyers. Many of them are great lawyers, but they get to pick the cases they bring to trial, right? So they don't bring dogs to trial. If your favorite sports team could pick the opponents it played, they'd have a 90% win rate too. So and they always have 20 times as many cases on their desk as they could possibly bring to trial. So they're cherry picking the most favorable cases for conviction. And if they're looking at that investigative report and they're seeing these kind of conflicting statements over and over again, they're like, that looks juicy. That looks like a vulnerability. That looks like a point of attack. For any of you who do martial arts, that's a point of attack for a prosecutor. And if he sees those vulnerable points of attack, you look vulnerable to conviction, just from a technical perspective, and you're much more likely to go to trial.
What about, this is a question I don't see answered very often, but I get it from time to time, is what do you do between pulling the trigger and when the police arrive? And I'll give you my kind of framework for people, and you can build off or tell me I'm an idiot. That's fine too. My thoughts are simple. First thing you do, you shoot. If you pull the trigger, you shoot someone, they're down, and you're now in safety, right? You're now in safety. I think. Well, I'm assuming you are in safety at this point. The situation is calm. Now you call the police. You call 911. You say there's been a shooting. I'm here, and you either. I would suggest telling them that you are armed, but your weapon will be unloaded or whatever, so that they come up with the expectation of who they're going, and you can describe your clothes. Then the next call you make, in my opinion, is to your attorney. to let them know what's going on. Ask them to get there as soon as possible. The
Because,
third,
of course, nobody has an attorney.
well, you
Nobody
should
ever has an actual attorney.
right. If you're carrying a firearm, you should have some criminal defense attorney with some experience in it. You should have their phone number in your wallet or in your phone or whatever. That's another piece of my personal advice, even though I know most people don't. So after the attorney call, or if you don't make the attorney call, make sure you take care of things at home. In some level, look, honey, I'm not coming home tonight. I've been involved in a shooting. Or, hey, can you go pick up the kids? Blah, 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 whatever that is. And then my next, and I know this is a lot of steps, but I hope people just get some of them. The next thing is, since you've got your phone, start taking pictures of everything. Like you said, the lack of evidence is often more of a problem. And I think having pictures is really important, especially if the person had a gun, if they're, are blood stains in various places. And the reason I came up with the idea of the blood stain thing was Darren Wilson. A lot of his innocence was based on the distance of the initial blood stains from when he first shot towards where Michael Brown ended up. And there was something like a 20-yard distance of blood pooling. And it would be really unfortunate if a rainstorm or something came before the forensic photo team showed up. So the other thing with the photos with the camera is that you can take pictures of witnesses who might be around as well. But some people don't like to have their picture taken. But I think if it's your life on the line, you can snap a photo from a distance and maybe help the police identify who is actually there. That might be useful. But those are the kind of things that I have told people. That's the type of thing you should do. And I think the phone is a tool that we all have now that wasn't really around and as developed when self-defense law was originally created. And I think it gets overlooked as a defense tool, is we have the ability to take pictures and record conversations if we need to. But I was hoping for your opinions on that.
Yeah, I don't think anything you said was unreasonable, but I think these situations are so dynamic, it's hard to have a strict set of rules.
Right.
So in my experience, most people involved in a self-defense event don't have an attorney. Anyway, they don't have an attorney to call. So that doesn't work. But even if they had an attorney, I have to be honest, my preference would be for them to not call their attorney. So a lot of self-defense events occur at night, right? That makes sense. Your attorney's not answering his phone at night, right? You're going to get an answering machine. So he's not coming to the scene anyway, because he's not going to hear that message until the next morning or whatever. I would call someone, I would call the person who is most likely to take your phone call, whether that's your wife or your brother or a son or a daughter, because once you reach out to the outside world, that person can make an infinite number of phone calls for you. But the moment the cops show up, guess what's happening to your phone?
Yeah, it's taken.
It's taken. By the way, that's also true for all the photos you took. So that's taken by the cops. Now, hopefully that evidence is preserved, probably, but it wouldn't be the first time I've seen evidence go away.
No, that never happens.
Yeah. So I'm not saying taking pictures is a bad idea, but I wouldn't want my defense to rely on my digital evidence that's immediately handed to police officers who, come on, let's face it, they lose stuff too, right? They're just human beings. And sometimes the stuff that gets lost is really important to your defense. If you knew that you could get a lawyer on the scene quick, I guess that would be advantageous. But the truth is, if you know enough to shut up, you don't really need a lawyer there at the scene. I mean, the real reason you want a lawyer is so you don't say anything stupid. But if you know not to say something stupid, your lawyer is not going to have a substantive effect until later anyway. So if you know to keep your mouth shut, just have someone get in touch with your lawyer, make him aware of what's going on. He'll get there as quickly as he can. Just don't start blabbing away and destroying your defense before he can get there.
The question was mainly anything between the situation being clear and the police showing up.
Just assume you're going to get arrested, folks.
Yes.
One of the most common questions I get is, hey, what can I say to reduce my chances of getting arrested? Oh, my God, it drives me crazy. Folks, forget it. Forget the concept of magic words that keep you from getting arrested. Either the cops will want to arrest you or not. If they want to arrest you, there is nothing you will say that will keep you from being arrested. Just assume that you're going to be arrested. It's the least of your concerns, folks. I could not care less if you get arrested. What I care about is whether you're going to spend the rest of your life in prison. And anything you say to try to mitigate your risk of getting arrested is very likely to boomerang on you and make it more likely you're going to spend 20 years or more in prison. So forget that. Just comply with whatever the officers want you to do. Comply does not mean be subservient, right? It doesn't mean answer all their questions. You need to remain quiet. But whatever they ask you to do, just comply with their, physical order demands, comply with the arrest. None of that is your concern. And by the way, for those of you who feel like you might have been unlawfully arrested, that's awesome. Deal with that later, right? If you think you were legitimately unlawfully arrested, by the way, you weren't. You were not unlawfully arrested. But if you think you were unlawfully arrested, that's an argument for another day.
What if I scream I'm an Article 4 free inhabitant and I was just traveling? Would that work?
I love the ones I love are the sovereign citizen ones. I'm a sovereign citizen. Or I had this guy in Texas who got into a shooting, and he was filming it on his own camera, and he kept saying, and he was on 911 at the same time, and he just kept saying, I'm standing my ground, I'm standing my ground, I'm standing my ground, like these are magic words that somehow make his conduct lawful. All it did was make him look like a lunatic.
Yeah, I agree. Say as little as possible. You will be arrested. You will be searched. If you have a vehicle there, it will likely be searched. I mean, they're gonna do those searches. I never advise anyone to consent to a search, but know that it will take place, and don't try and resist it. Right. You can simply say no.
Always say no.
Yeah.
And then physically comply with whatever, because they're going to do it anyway. If they want to, they'll do it. So just say no and then comply with whatever they're doing.
Right. The argument happens later, and it's the only important thing is whether or not you consented to it. So say no, and then they will get to prove whether or not they had the right to search you at a trial or at a hearing. But that's the main stuff I like to get people to focus on. Also, I don't know if people...
if the cops actually do an unlawful search, that's awesome for you.
Yes, that's great.
That's fantastic.
Definitely don't give them consent to do the unlawful search. And I think a lot of people don't know that. And I think this is a terrible aspect of American jurisprudence. You have to affirmatively assert your right to remain silent. You have to say, I am not answering any questions. I'm asserting my right to remain silent. And you also have to affirmatively assert your right to an attorney. To say, I will not talk any further without my attorney present. And then, only then does the interrogation end. If you're just sitting there quietly, even though you're technically asserting your right to remain silent, they can keep asking you questions until you actually say it. Those are the only magic words in the scenario. Those are no.
Ambiguous about it. Well, I don't know if I should say anything more without my attorney here. Guess what, folks? That's not an assertion of your right to counsel. I don't know if I should answer any more questions. That's not an assertion of your right to silence. And even after you've asserted affirmatively, explicitly your rights, don't get gulled into waiving that assertion. So cops are listen, best man at my wedding was a cop. Tremendous respect for cops, but they are clever, man. And if you assert your rights and they know they can't ask you questions anymore, well, maybe they won't ask you questions. But you know what they might do? They might have you at one end of a long table, and they and their buddy will sit on the other end of the long table, and they'll talk about the case. Hey, what do you think happened here? Well, I think he's a racist murderer. I think that's what happened. And you go, no, that's not what happened at all. And you start talking, and the moment you start talking, you've now waived your right to silence. Now you're talking again. Now they can ask you questions again. Sure, you can reassert your right to silence. But why do that circus? Don't let them gull you into re-engaging. Because if you re-engage, they can start talking to you about the case again.
And also assume that everything you do from the moment the police arrive is recorded. It's either recorded by body cam, by a regular camera, a cell phone camera. When you're in the car, everything you say in a car is recorded. Everything you say at the jail is recorded. Even though they're not supposed to record you on a phone with your attorney, it might be accidentally recorded by someone else somewhere nearby. You cannot ever assume that your privacy is being respected in that. And again, that's not actually a knock on cops. They have a right to record those conversations except with your attorney. But if it's ancillarily picked up, say on someone else's phone, that could be you talking too loud and then waiving your right to privacy. So, yeah.
By the way, I would also mention to people that don't wait to be Mirandized to assert your rights.
Right.
A lot of people think, like, because we see it in TV and the movies, right? That's the threshold. That's the moment that it's supposed to be done. Cops are perfectly happy they don't have to Mirandize you until they want to question you as a suspect in a crime. Even if they think they're going to want to do that later, they can pretend they don't want to do it in the moment, stick you in the back of a patrol car, turn that dash cam around, and just film you. And if you want to start blabbing away in the back of the car, they'll record that all night long. So you need to assert your rights when it's in your interest to assert your rights. Don't wait for them to read your Miranda rights, because they can delay that a long time.
Well, and they did that with the Boston Marathon bomber and his brother, I believe. When they apprehended him, he had been shot in the shootout with the police, and there was a big hubbub over whether or not they Mirandized him before they asked questions. And I mean, the real answer was they were looking for the answers of, are there more bombs? Are there more attacks? Are you guys acting alone or in concert with other people? Right. They didn't need those answers for a criminal conviction. So they waited to Mirandize him, hoping to get information out of him for that. Because they didn't need any info to charge this guy for the bombing. They already had that. So,
right.
Yeah.
I was living in Boston at the time. They,
yeah. It was that was messy.
They knew they had the right guys.
Brandon Temmel says the self-defense immunity sounds like it has a lot in common with TCPA and anti-SLAPP in general. Any thoughts on that comparison? Great show, guys. Now I know First Amendment speech civil defense isn't your realm, but are you familiar with anti-SLAPP laws or TCPAs?
Just conceptually, I have no idea what the legal standards are or what's required. I think self-defense immunity laws are among the, other than self-defense itself, are probably the most important thing we have going for us, because it provides us with the opportunity to demonstrate that self-defense without having to go through that process as punishment, which is the trial. So in most jurisdictions that don't have self-defense immunity, whether or not you go to trial is not your call, folks. It's entirely up to the discretion of the prosecutor. And if he wants to put you through a $300,000 trial, even if he knows he can't get a conviction, and compel you to sell your home, your business, cash out your retirement accounts, cash out your kids' college accounts, beg, borrow, and steal every dime you can from family and friends, it's within his discretion to do that. He can do, or she can do that to you. That's within their power, unless there's a self-defense immunity statute and you can demand that pretrial hearing and get that decision called before a trial, without a trial, for $5 or $10 grand, without having to go through that whole expense of a trial. So I think these self-defense immunity laws are unbelievably important. Frankly, much more important than stand your ground. And I am a big fan of stand your ground. I think it's good public policy. But the truth is, in my experience, the cases I work on largely involve normal, law-abiding people who've never been in trouble with the law before a day in their lives. And if they had a chance to safely flee a fight rather than shoot someone, they would have done that.
Yeah.
So stand your ground laws, in my experience, they're good. They should be on the books. I'm a fan, but they don't generally apply to good guy cases of self-defense, because most good guys don't say, F you, I could safely retreat, but I'm going to get into a gunfight instead, because they're smarter than that.
Right. They want to go home and they know the gunfight means they might not.
Right.
I actually had a not one-to-one comparison because it wasn't a shooting incident, but I had a domestic violence case, and my client had asserted from the get-go that he didn't do it. He was not the abuser, and his defense relied on the stepson basically taking violent action against him. And even when I presented the letter from the prosecution's key witness, who was the alleged victim, right? The alleged victim was the longtime girlfriend of my client. And he said, I presented a letter from the girlfriend that said, this guy actually didn't hit me at all, ever. It was completely a lie by my son, who was mad at him for other things. And the son had actually assaulted him. I presented the letter. He said, no, we're still taking this case. We're still going to do it. I'm still going to prosecute this guy. And then we got to our omnibus hearing, our pretrial hearing for the guy. And that morning, the son had pled guilty to everything that was in the letter. He pled guilty to assaulting the stepdad. He said that the entire incident was his fault and that he lied about the statements to the police, saying that the stepdad assaulted it. And the prosecutor still wanted to bring that case against my client because he was just convinced that my client had abused this woman. And that was the case he was going to go with. We eventually talked him out of it.
More accurately, he was convinced he could convince a jury that your client had done that.
Right. And this was a misdemeanor domestic assault too. So this was not like a big case or anything, but he was just convinced.
In some senses, right? Loses your gun rights forever.
Oh, right. I mean, it's huge for the person, for the defendant, but I meant for the prosecutor, like it's just a misdemeanor case. It's not like it's going to make his career, but he was so intent on, I can get this. He was even telling me what witnesses he was going to get disqualified. I'm like, wait a minute. Why are you doing this, man? Like the kid said he did all of this and lied to you. It's like, well, I'll get him disqualified as an admitted liar. I'm like, geez. But the point in this is prosecutors do have that much power to ruin your life. So you have to take this stuff seriously from the start. And you really need to get into the mantra of, I will not answer these questions. This is my right to not speak.
And don't get into fights you don't need to get into. Keep in mind, the moment you get in that confrontation, you've just incurred a greater than zero risk of dying in that fight and a greater than zero risk of going to jail for much of the rest of your life and being utterly destroyed financially. There are stakes that are worth those risks, but they're not many of them. Right.
Only Wagyu steaks. That's a joke. Nova Zero says, what if you ask for your lawyer dog? Are you familiar with that case? That was
no.
It was in Louisiana. A guy said in urban parlance, we'll say, he said, "Look, I'm not talking until I get my lawyer dog." And the judge, and I believe the Supreme Court of Louisiana agreed that he was literally asking for a lawyer canine, and therefore had not asserted his right to an attorney. And the Supreme Court of Louisiana upheld that. So that guy went to jail.
Well, it would be inappropriate for me to comment on the appearance of some of female counsel. So
yeah. Oh my goodness, that was a little spicy. I liked it. Okay, I think as far as questions that I have, I'm about done. I think the Ahmaud Arbery case, you've kind of opened my eyes to what the factual situation is, and you've sold me on the idea that this is a self-defense case more than a citizen's arrest, and all of this other stuff is just social fluff. And look, if you don't like how the law in Georgia is written around this stuff, change the laws. And that's often the answer to these social issues. Change the laws. And we never want to discuss that because it's hard, but that's the ultimate issue here. And then as far as the self-defense immunity, yeah, I agree. I think those are very important laws that need to be more prevalent amongst the states, because you should always have the opportunity to avoid this kind of disaster happening to your life if you're in the right. And if you're not in the right, or if it's fuzzy, then you go to trial. But nobody else needs to do that. So I do have a couple more questions from the chat if you're willing to hang out for them.
Yeah, I'm good. Let's go.
All right, let's go. Mr. Leon says, what's your guest's favorite jogging hammer?
Jogging. My favorite jogging hammer is a Sig 320.
Oh, okay. I waver between claw and ball peen. Lil Poo Poos says, Nick, Gino Fury 666 refused to let me speak to the manager after denying my pre-stream alien cat girl. I don't even know. I suggest she be given to me or I'll be forced to take legal action. Good day, sir. Thank you. I hope you get your pre-stream alien cat girl. Mr. Leon says, Nick, shush and let the real lawyer talk. Ouch. Ouch. Callaghan Voyater says, I've got me some Jameson whiskey, a cat named whiskey, and some lawyer tube. I'd say my birthday's starting on a good note. Cheers. Have some funny money. Thank you. Zetsu Himose says, thanks for talking about this. His sister and I were in band together, it's less a race thing than a corruption in Brunswick. Now, whose sister, Zetsu? Do you mean the defendant or the deceased?
And by the way, there's lots of reports about criminal justice, governmental corruption in this jurisdiction. I don't know anything about that, but none of that, folks, is relevant to the facts of this case for these defendants. So,
right.
Just please, the media likes to talk about this stuff because the media is in the business of generating outrage and getting clicks and blah, 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 blah. They have to have stuff to talk about. None of that is relevant to the case at all. And I'm not saying the jurisdiction doesn't suck. It may suck. I have no idea whether or not it sucks, but it has nothing to do with the legal analysis of this case.
Right. And for my part, I haven't seen anything yet to back up the idea that there's a racial element. I mean, the only racial element I've seen from the media or anyone else is an inferred racial element because it involves white shooters and a black victim. And maybe there is racism there, maybe there's not. I have no idea, but I've strayed away from making any sort of judgment on that because there's no support to it. And if there is, like you said, if we find a bunch of social media posts from these guys that have the N-word all over the place, that's going to really complicate their defense really quickly.
They're done if that happens. If only because it suggests a motive other than a lawful motive for their pursuit and stop, and it suggests a racist motive for doing that. So if that stuff emerges, I mean, you just got to write them off. It's all over. But as you say, there's literally zero evidence of that. Now, I will say I recently read an appellate court decision that had a dissent. And the question in the decision, the key issue was whether or not it was inappropriate for a prosecutor to suggest a racist motivation on the part of the defendant. And there was, in fact, no evidence of a racist motive. So the prosecutor was just making that up. And the majority said, no, that was inappropriate. If there's no evidence of a racist motive, you can't just throw it into the case. That's inappropriate. The dissent said, well, racism is institutional, so it's always appropriate to throw it in.
Oh, my God, no.
Can you imagine? Independent of any evidence to that individual defendant that they're racist, you can always suggest it to the jury. But this is a justice on a state Supreme Court. Now, they were in the dissent, so it's not a controlling opinion, obviously. But if there's one, there's more than one.
Yeah, and that might be the more than one might be your district court level judge for this case. And the other thing, what's kind of scary on the social progression scale as far as jurisprudence goes is present day dissent makes future law in a lot of cases on social issues when we're talking about socially progressive issues. And you can go back to the dissent in Dred Scott shaped modern civil rights law, even though it was the dissent. And so there's always risk in those sort of things. And that's where the policy argument comes in. Like, look, I know we have this, but look, this dissenting opinion from this very reasonable judge said that everybody's racist.
That's fantastic, by the way. I always encourage people. So I do a show every week, every Tuesday, called Cases of the Week. We look at the use of force appellate court decisions from the last week from the whole country. We just pick 3 or 4 of them to highlight. But the cases I love are the ones with the dissents, because if there's no dissent, you're only hearing the winning argument.
Right.
The winning argument's not the only argument. I mean, it wouldn't be in an appellate court decision unless there were 2 sides arguing. When you get a dissent, at least you're hearing the other side of the argument. It gives you a tremendously more context than would otherwise be available in the decision. And I don't care if the dissent sucks or if the majority sucks or whatever. If you have both sides of the argument, you're learning a lot more from that court decision than if you're only hearing one side.
Yeah, and a great case that I can personally advocate for reading the dissent to get more of a contextual understanding is a famous Supreme Court case that is controversial, Korematsu versus the United States, the internment of the Japanese. When you read the opinion, you're like, okay, well, the U.S. had this reasonable expectation that there were a bunch of spies. When you start reading the dissent, you start to see all of these other factors, like people really wanting Japanese farmland, and then that farmland getting distributed to them, and people really wanting these Japanese stores. And it really rounds out the case in a way that you would not have understood before. So that's certainly great. Where can people find your podcast? Is it lawofselfdefense.com?
Yeah, I mean, we're on Facebook at Law of Self-Defense. We're on. We don't do that much social media because I'm not in the business of providing free content to social media. So, but we do typically put our most recent one video on Facebook. But if people want more broader exposure to what we do, the best place is lawofselfdefense.com. We have I should mention, so one of the things we've done is we've distilled the law of self-defense for all 50 states to these 5 core elements is a fundamental framework of self-defense law. We have this, I'm holding up a little 1-page infographic that we've done. It provides a brief description of each of those 5 elements. Folks, it's free. You can get this for free at lawselfdefense.com/elements, plural elements, lawselfdefense.com elements. Doesn't cost a penny. Download it, because if you don't understand those 5 elements, the truth is you have no idea what self-defense law means. And I know a lot of you have been to concealed carry classes or maybe a law shield class or whatever, where people talk about self-defense law for an hour or so. Folks, unfortunately, it's extremely dangerous to assume that just because someone has a particular job title that they know anything about self-defense law. I can tell you in 3 years of law school, we spent maybe 5 minutes talking about the legal doctrine of self-defense. In first-year criminal law, it was not a lot. So most lawyers, by the way, if you're not a criminal defense lawyer, you have no professional need to know self-defense law anyway, right? If you're doing real estate law or tax law or whatever, all legitimate pursuits, but you're not doing self-defense cases.
Right.
Police are taught more about use of force law than attorneys by far when they go through the police academy. But the truth is and if there are officers in the comments, I encourage you to comment whether or not you agree with what I'm saying. But in my experience, most of what police officers are taught in the academy is not intended to protect that police officer from personal criminal liability for his use of force. It's intended to protect his department from civil liability when they're sued for his use of force from federal 1983 cases. And those are 2 completely different things. Who pays for his education at the academy? It's not the officer, it's the department paying for that, and they're paying for their own protection, not that officer's protection.
Yep.
Firearms instructors, I'm a firearms instructor myself, have been for decades, and it's not because firearms instructors are incapable, but frankly, the resources they have are not good resources for actually understanding what self-defense law is, and they end up communicating a lot of bad information to their students often. So what I would encourage people to do is actually the ultimate source for the law of self-defense is not me. It's the actual law. It's the statutes, the court decisions, the jury instructions. We can facilitate your ability to access that stuff. That's where you want to go.
Absolutely. So Rogue says, it's amazing how fast people buckle under threat of perjury when it really matters. A lot of I saw X, I heard Y, and it happened to me at Z with Vic. The silence of Veronica's allies is golden. Yes. That's an unrelated
statement.
Yeah.
That's a wonder of the law, actually. People will talk all kinds. Are you allowed to curse on this show?
Absolutely.
People will talk all kinds of bullshit in casual conversation, make up all kinds of lies, say all kinds of crap. You put them under oath and they're facing penalty of perjury, and all of a sudden everything changes because now they could go to jail for that bullshit and those lies and that crap. It's a very powerful tool. I'm a big fan of it. And of course, we're seeing it at the national level right now with all these investigations of Trump, where people were willing to talk about all kinds of shit they made up when they were talking on the cable and news channels. But when they were under oath, it was a different story, wasn't it?
Oh, very quickly.
Now they're subject to imprisonment if they're caught lying. Makes all the difference.
Absolutely. Snap says, any opinion on the Alan Scarcella case? Even video from the protesters claimed that the group was being chased. It seems like him and his friends were turned into sacrificial lambs. I'm not familiar with Alan Scarcella. Was that the Proud Boys case up in New York? Let me just do a Alan Scarcella.
Yeah, I'm not familiar with it by name.
For shooting at Jamar Clark. Bloomington man convicted of shooting and wounding 5 men at a protest over the 2015 police killing of Jamar Clark. I'm not familiar with this case at all. I've never even heard of it.
It does remind me of a case I think that is worth knowing, and that is there's a case out of I believe it was Portland, Oregon, Michael Strickland. Michael Strickland was a conservative blogger. I don't know him personally, so I have no interest in him as an individual, but he was a conservative blogger who went to an Antifa protest or march to document, to film what they were doing. He was known to them, so he was recognized by them. He was, he says, threatened by them. He pulled out his gun, didn't shoot anybody, simply drew the gun. He ended up criminally charged with something crazy like 20 counts of aggravated assault with the gun and convicted. And he's serving much of the rest of his life in prison as a result. And I would just caution people that his mistake was partly a mistake of where he was. So he was in hostile territory for his political views. He should have considered, if I have to defend myself in this jurisdiction, so this is an Antifa march that he's filming. They're his opponents. They're the people who hate him. Is the local jurisdiction favorable or unfavorable to Antifa's political position? They're favorable to Antifa and unfavorable to him. What's that mean in terms of the cops that respond to the scene, the prosecutor who's trying the case, the judge who is going to be in charge of that case, the jury pool that's going to be selected from those same people in that community? That's not favorable to him. People often ask me, Andrew, what's the most important thing I can do for myself in terms of self-defense? And they're often thinking in terms of a weapon or a gun or a tool. And folks, the most important thing you can do for yourself in self-defense is live in a place with people just like you. And I don't mean that in terms of race or religion or anything like that. I mean, live in a place with law-abiding people. They want to be left alone so they can live productive lives, but they also want the privilege to defend themselves and their family from a violent attack. You want to live in that community because first of all, the risk that you'll be subject to a violent attack in that community is zero. It'll never happen in that community. But if it does happen, guess who the cops are? Guess who the prosecutor is? Guess who the judge is? Guess who the jury is? They are those people, just like you, who just want to be left alone, but have the privilege to defend themselves from violent attack. That's the jury you want. It's when you go into, I don't know what to call it other than hostile territory. You get charged there. You get arrested there, you get reviewed by a prosecutor there, you're in front of a judge there, you're in front of that hostile jury. Man, all the facts could be exactly the same. All that's changed is the jurisdiction you're in, and the outcome is completely different.
Right. And that's something we talked about before the show that I think merits repeating, is that you framed it this way. See, a lot of people look at the criminal justice system as if it's a supercomputer where you beep, boop, beep, you put in the facts, you put in the law, you hit print, and out comes your not guilty verdict. But it's not really that simple. And it's not a pure math function. You have variables, and those variables are jurors, and the makeup of those jurors is relatively predictable based on the available pool. And that's what you're saying here, is that, look, if you live...
People, folks, it's just people. It's just human beings. The cops are human beings, the prosecutor, the judge, the jury, and they have all the great characteristics and all the failings of human beings. They can be kind and smart and loving, and they can be hateful and envious and have their own agendas. And when you get engaged in a fight, you're putting the rest of your life in those uncertain hands. And maybe you'll get a favorable outcome, and maybe you won't. In either case, it's what our system calls justice. Justice is not the outcome. Justice is the process. And the idea is that the process is that we're all similarly situated people will be treated essentially the same going through the process. But essentially the same has a lot of noise in that signal, a lot of variability in the outcome because it is human beings involved. It's a high risk venture.
Right. And you don't want to be defending a self-defense gun case in Berkeley, for example. Like, that's just not what you want. You want to be defending it in Montana. Polyfrog64 says, Nick, this guy is embarrassing you. I hope all of my guests embarrass me. I like to bring on... No, don't worry about it. But I like to bring on people who are more competent than me. That's what the goal is.
I would point out that in my current stage of my career, Nick is way more of a go-to-court lawyer than I am. I don't go to court anymore. I'm a legal consultant, so I don't take clients directly. All the cases I work on are cases where someone's been charged for a use of force crime. They're claiming a self-defense justification. They retain a lead counsel in whatever state they're in who's licensed to practice there, and I consult to that legal counsel. So my client is their attorney. My client's not the person who's been criminally charged. Their attorney's taking all the risk. Their attorney's doing all the hard work. They have to go to court. They actually have to argue the cases. I just deliver them an expert report. So all the hard work, all the high risk work is actually being done by the go-to-court attorneys like Nick.
Well, I don't go to court as much anymore. I have a couple still lingering. Once COVID's over, I'm going to have to deal with them, which I'm not looking forward to, but it's been nice not having to respond to everything.
I think someone asked in the comments, so you don't own a suit? Yes, I own a suit.
You're in a tie.
It's an astonishingly expensive suit.
Yeah.
I bought cars for less money than these suits, but it's part of the uniform.
Some nobody says, ooh, so this is like a real lawyer. Yeah, exactly. Brian Wolf says, how could they establish intent of burglary now that Ahmaud is dead? Did you want to take the... I think you mentioned that it's not really relevant whether or not you can establish the intent of burglary. I
don't think it matters because it only matters for the citizen's arrest purpose, and I don't think citizen's arrest matters here. But the way you normally establish intent is from circumstantial evidence.
Right.
So, had he previously stolen stuff, for example? If he's a known thief, well, that would contribute. And in this particular case, the father, Greg McMichael, well, we don't know if he investigated this particular case, but we do know that Arbery had been investigated for shoplifting, for theft.
Sure.
So Greg McMichael knew that. Well, that would contribute to his reasonable suspicion that a theft might be occurring, or at least an intent to steal. And if there's an intent to steal possible, all you need is a suspicion, right? If there's a suspicion of an intent to steal, and the unlawful entry is incontrovertible, there's no question that Arbery didn't have a right to be there, well, then I think you have a reasonable suspicion that he's there with an intent to steal. It doesn't have to be an absolute certainty. You don't have to know for a fact. It just has to be a suspicion. Is it enough for a suspicion? That's the question.
Right. And one of the questions about that is it reasonable to assume that he was going into the property to steal? Well, if your immediate assumption is no, then you have to provide a reasonable alternative that he's entering that property. And maybe there is one, but again, it's really, was that information present in the minds of the McMichaels at the time? Again, if this becomes relevant as a citizen's arrest sort of case, is what would a reasonable person situated in the shoes of the McMichaels at the time of the event have thought? And I'm sorry, but most people don't break into construction sites to watch like Netflix on someone else's TV.
I mean, they might, right? But
right.
The point is, if you have a doubt about it, could they be stealing something? Well, that's a suspicion, folks.
Yeah.
You have to know that. Now, it would be different. Say, for example, you had observed an actual construction worker go in and out of the site every day for the last week, and you saw him go in for an 8th time. It would be unreasonable to assume that person was going in for the purpose of stealing. But when you see a person go in who perhaps has had theft charges before, unlawfully trespass on a property, is that enough for a mere suspicion that he might be stealing something? And I think it probably is. Now, again, I don't think it matters, because on the facts of this case, I don't think, in fact, citizen's arrest is relevant, because they didn't actually arrest anybody, and they're not justifying any of their conduct on the basis of citizen's arrest. So from a technical perspective, I don't think it matters. But if it does, I mean, I think there's a reasonable case to be made that there was grounds for suspicion, which is all that's required.
Right. I agree. Until different evidence comes out. I mean, I think so. Revox says mens rea actus reus. This is a clear example. I don't know exactly. Are you saying that the criminal intent lies on whom? That's the question. Are you saying the McMichaels? I don't know that we have any evidence of their criminal mindset for the mens rea element. The actus reus, of course, they did do, the son did shoot.
Unless it was accidental over the fight with the gun.
Right. Well,
and
I mean, but
neither of them have actually been charged with an intentional use of force.
Right.
So even the prosecutor is not comfortable claiming they intentionally used force, or they would have been charged with battery at least.
Yeah, sure. That's true. Tamara Holloway says the father was on with 911 before and during the attack. Yeah, we covered that earlier. Bill Keller says, didn't the elder McMichael have previous knowledge of Arbery's criminal history from his time as DA investigator? I don't know that we've established that he definitely had that knowledge, but it's possible, right? Is what you said earlier.
He definitely had knowledge of investigating Arbery for a unlawful gun possession crime. What we don't know is if he recognized Arbery as that person, because there's no statement to that effect. Like in the incident report, he doesn't say, "Oh yeah, that's the guy I investigated for the gun crime." He doesn't say that.
Sure.
So we don't. He may, in his mind, he may just be chasing another person who happens to be a black male suspect fleeing from a robbery, and hasn't connected it. Now, of course, once he talks to his defense attorney, I'm sure he'll connect it. I mean,
oh yeah, I definitely remember that guy and did at the time. Bad Dragonite says, Nick over here with the cute trap questions. Yes, that's what we do. K Osk says, I don't know why, but you say words, he hears words is cracking me up. Oh, okay. Crusader Saracen says, this guy is a great guest, Nick. General question. I live in California. Any tips on how not to get jailed forever for shooting a home invader?
Sure. Move out.
Yeah, move to Wyoming.
Hey, Colorado's got the best home defense law in the country. You don't even need to be facing a deadly force threat before you can use deadly defensive force. If you're facing an unlawful intruder in your home who threatens any degree of harm to someone within the property, that's the most generous defensive habitation law I'm aware of in the country. And not to brag, but I've read them all. So,
yeah, Colorado is a interesting blue state because
it's changing, unfortunately.
Yeah, well, that's probably the thing. It's the law lags behind the populace, but
right.
But for now, they like Minnesota though. I live in outstate Minnesota, and yeah, we have a strong pro-gun, pro-self-defense culture because it's all farmers out where I live, and farmers, hunters, and outdoor folk tend to enjoy their guns. But the rest of the state,
they elect the prosecutors, and the prosecutors know the jury pool is going to be those people.
Right.
Yep.
Right. Someone's asking if there's a real answer for California. I think the answer is there's not really a good answer. Other than to move away, is there? Like, what do you? I mean,
listen, I've been to California. I love California. It's perhaps it's certainly one of the top 5 geographically most beautiful places in the United States. It's absolutely gorgeous. The politics, unfortunately, are insane, and I say that as a person who lived for 25 years in Massachusetts, which is insane as well. I think the only thing you can hope for is that somehow the I don't know how to put it without sounding derogatory, the kind of the tumor that is California distributes itself across the country in such a way that it doesn't just metastasize and infect every other state, but instead gets diluted across the other states. And there may be signs of that, frankly. I mean, I'm seeing now that many of the big tech companies, for example, are given the COVID situation, are saying, hey, you know what? We're going to give up a bunch of our big office buildings and let people work remotely. And if people can work remotely, we don't have to pay them enough to live in San Francisco. We can pay them to live in South Dakota or North Dakota.
Right.
Places that are really inexpensive to live in. And then we don't have to pay people enough to afford a 1,200 square foot, $2 million home, but a 1,200 square foot, $50,000 home, and it's going to be a lot less expensive for us. And if they do that, that completely changes the culture of those tech companies. So Google changes, Facebook changes, Twitter changes, because just like with the court system, we talked about that. We'd like to think it was a supercomputer, but it's really just humans making decisions with all their failings and all their strengths. It's the same for these tech companies, folks. And they're going to be different companies if they're all concentrated within San Francisco and Palo Alto than if they're spread out throughout the U.S. and more representative of the rest of the U.S. You'll see very different decisions made by someone in South Dakota than you will from someone in Palo Alto.
Exactly. I think that's a good answer. Rogue says, I don't recall. Looks like my tweets. Is that a good defense? Yes or no?
I don't know what that means.
No, it's terrible. Crusader Saracen.
I would tell people, by the way, I would caution people that everything you put on the internet is there forever. Nothing is ever actually deleted. When the cases I work on, the first thing law enforcement does now is they get warrants for the person's social media. They get everything. And every once in a while, a Facebook or a Twitter will try to put up some token resistance to giving up stuff that's been deleted, but they always lose that battle. It always ends up getting coughed up. By the way, especially if you've killed someone, if it's a murder case, the authorities are going to get whatever they want. So I would urge you not to put anything on social media that you're not prepared to have read in court in front of a jury.
Rip. Rest in peace. Crusader Saracen says, was Drejka's legal team bad, or was it that he didn't follow the golden rule of not talking to police and Christ himself couldn't save him in court?
Well, his talking to the police was bad. It was very damaging. I would, if I was his defense attorney, I would have punched him in the face for having done that. But it's also true that even given that, I don't know. I honestly feel he had a shot at acquittal. He had a narrative you could argue in court. There was a credible claim of self-defense to make there, but it would have taken an exceptional defense team to do that, and he did not have an exceptional defense team. They, as far as I'm concerned, I mean, I don't know. I can't read their minds, but to me, it looked like they just wanted the headlines, and they all worked for free. By the way, he didn't have any money. So They all volunteered basically to work pro bono. And if you're working pro bono, what are you working for? It's not for the money. It's for the headlines and the attention. And they got that. So for them, it was a win. For Drejka, man, I remember one point in particular strikes my mind. They hired a use of force expert witness to testify on behalf of Drejka. And that's when I was expecting, hey, let's talk about the Truller drill. Let's talk about how difficult it is to perceive events accurately if you've been knocked to the ground. Let's talk about all this technical detail. The guy they hired was someone who had installed a security system at one of the lawyers' homes the week before. They knew this expert witness for 1 week before. He's not an actual expert. And then they fumbled the questioning of the expert. I mean, it was a catastrophically bad represent. They would have been better off without an expert witness and just having the lawyer talk to those issues in closing than the expert they brought in. And by the way, the expert I felt so bad for because he showed up. I'm sure they told him, hey, this will be easy. Just sit there and answer some questions. And he showed up, and then he was subject to cross-examination. And if you've never, by the way, been subject to cross-examination, that is not a pleasant experience if you're not well prepared. And the attorney cross-examining you is skilled. That is getting gutted on the witness stand, and that's what happened to this guy. And he looked awful. Although I'm sure he's perfectly good at installing security systems.
Right, but you know the interesting thing about that is now he's publicly been exposed as maybe not looking so expert, yet that's part of his sales pitch for his business. So it depends on how much. I'm sure it will be,
right?
Yeah.
Court approved as an expert witness.
Polyfrog64 says, stay back. High-pitched scream. That was an interesting.
That's good. I like that advice.
Yeah, that was so.
I'm a big fan of using your voice. So here's the thing with verbal commands. We all like to think, we see the police do it, right? Drop the gun, all these kinds of verbal commands.
Right.
To my mind, at least for civilians in self-defense situations, the value of verbal commands is not to compel the other person to comply, because you have no control over whether they're going to comply or not. You can't make them do the thing you're saying.
Right.
The utility of the verbal command is greatest in situations of ambiguity. So for good guy cases of self-defense, we don't tend to get into trouble, legal trouble, on the extreme ends of the spectrum. So if there's no threat to us, obviously we just go about our day, right?
Right.
If some guy steps out of an alley with a raised machete and tries to hack our head, well, that's not a complicated legal situation. You just shoot that guy, right?
Yeah.
It's in the middle zone. It's where there's a guy who's scaring you, but you're not sure. You're a woman in a parking garage at night, and there's a creepy dude, and you can't just shoot him because he hasn't actually done anything yet, but he's scaring the F out of you. And, well, what can you do about that? Well, you can use your voice. You can use your voice to compel him to either stop doing what's scaring you or to act as a threat that you can defend yourself against. So if you're that woman in the parking garage, there's a guy 30 feet behind you, looks creepy. I mean, for all you know, his car happens to be parked where your car is, right nearby. So he's walking the same way, just like you are. Don't worry about that. Just turn around. Tell that guy to stay the fuck away from you. What's a normal guy going to do? Holy shit, I'm not going near that lady.
Right. Yeah.
Right? What's an actual rapist going to do? Oh, fuck you. I'm going to keep closing distance on you. If you're shouting commands at that guy to stay away, does it make him stay away? No. But does it compel him to either stay away or act consistent with being a threat that you can defend yourself against? Yes. So what the verbal commands do is they strip away the ambiguity. They clarify your privilege to use force in self-defense in a way you can articulate to other people. They'll say, well, why did you think you had to shoot that guy? Well, I screamed at him repeatedly to stay away, and he kept coming closer. That is an evidence-based rationale for your use of force. That is extremely compelling, as opposed to, by the way, I've worked on cases where we had female defendants saying, oh, that guy just scared me. That is not a compelling narrative for pointing a gun at someone, much less shooting someone.
Right.
But if you can say, I screamed at that guy to stay back and he kept coming closer, that is compelling. And a prosecutor knows that will be compelling to a jury.
So hypothetically, if you're like a 130-pound Canadian woman in Florida and you're being pursued across the city from a bar by like a 250-pound Canadian guy who had just like ripped his shirt off at the bar.
Isn't that just Florida?
Yeah, it is. But you get kind of backed into a corner. You should yell like, stay back, stay the fuck back. You've got, and draw the gun. And if they, that helps with the decision of if they keep pursuing and you pull the trigger.
You don't have to yell anything. You don't have to yell a word before you can act in self-defense. But
right.
If there's ambiguity about the situation and you're not sure what's going on, you're not sure if you should be using defensive force, then those verbal commands can be very helpful in clarifying, removing ambiguity from the situation. So if you don't know if the guy's walking up to ask for a light or the time or to rape you, well, yell at him to stay away. If he's just asking for a light or the time and you're screaming at him to stay back, he's going to stay back. If he's there to rape you, maybe he won't.
Yeah. And it's contemporary evidence of the state of mind of the person acting in self-defense, and anybody around him. Like, he was yelling to stay back.
That's another great thing. By the way, what do we all do when we hear someone shouting in public? What do we all do?
We all look.
We turn our heads and we look, right?
Yep.
More evidence is good for us. If you're shouting, people will at least look. You have more witnesses. And by the way, you might attract some dummy who doesn't know how dangerous it is to come to the defense of other people, actually come to your defense, which would be awesome, right? I mean, if you can actually recruit strangers to help defend you, I mean, that's the best world scenario. That there's no legal risk to you for that. The legal risk is all to them, but they might not know, so they might do it anyway.
Right.
That would be. I would love that. If I could scream, listen, if I'm ever faced with a situation where I might have to shoot a dude to save my life, save the life of my family, I'm going to be screaming like a little girl. And if a bunch of people come and try to save me from that dude so I don't have to shoot him, that is a win, 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 win all day long.
Yeah, I agree. Nick Naylor says, yelling, quote, "I'm standing my ground. Worski, is that you?" So this is all from a case that actually happened down in Florida involving another YouTuber by the name of Andy Worski. And he wasn't the guy who had the gun, but his U.S. resident friend Alex had to draw a gun. They were kind of pursued across town. So he's kind of mocked for yelling "stay back" and all of that stuff. But I actually referred him to his lawyer down in Florida, and he was acquitted. The guy who drew the gun, so it was good times. But Polyfrog64 talked to him about Warski. Yes, there you go. John Hu says, opinion on China dodging a war bullet with the U.S. with their rocket failing launch, missing New York, but hitting Africa instead. I have no idea about that.
I would say that international politics is not my area of expertise, but if anything, anybody thinks we're not currently in a state of war with China, they're just not paying attention. So it's a non-shooting war at the moment. But if you think we're not at war with China, you're not paying attention to what's going on. So
yeah, absolutely. We haven't been in a hot war. I mean, other than Iraq and Afghanistan, but we haven't been in a superpower hot war for a very long time. But we've been in a somewhat of a cold war with China for quite some time, and they're pretty overt about it. We still trade with them and stuff, but my goodness. I mean, the
good news is they're very predictable. So they will seize upon taking the advantage if they perceive America as weak. So all we have to do is not be weak, and we're fine. Unfortunately, every once in a while we elect, not currently, fortunately, but every once in a while we elect leadership that is weak, and then they take relentless advantage of us. And if we elect a weak leader again, you should expect China to do the same thing again. So,
what if we elect someone who doesn't remember that China exists?
Yeah. Yeah. It's funny that the criticism of Trump, of course, is that statement he made on record where he said there's some gals out there you can grab them by the, and I won't say the word.
Yeah.
But now the credible claims against Biden is not only can you do that, but you can grab their ovaries. I mean, you can actually reach inside them.
I think Biden's trying to sniff them by the hair. Don't, guys in the chat thought I was going somewhere else.
It's just so creepy. When they used to do the memes of him washing his Trans Am in the driveway of the White House, that was just funny. But the relentless groping and touching and smelling is just
it's a bit much.
Is there anybody in this audience who would allow that man around your minor children unattended?
I would scream "stay back" in a high-pitched voice.
I mean, you just wouldn't do that. Even if he was your favorite uncle, you might say, okay, we got to invite him to Thanksgiving, but make sure he's not alone with the kids, right?
Right.
You're going to elect that guy president of the United States? That's not going to happen. I hope it's not going to happen.
Yeah, I hope not too. He seems like a disaster, even without all that stuff. But yeah. Ninja Work 111. Oh, wait, no. Paul Delaney says, Andrew, who is your favorite god of chaos and why is it Papa Nurgle?
My favorite god of chaos is the best man at my wedding.
Oh, okay. Who is also a cop.
He's had a very diversified career in the military and law enforcement. If I needed someone to protect my back, he would be that guy. And I don't know what the rest of that sentence means. So,
oh, that's okay. It's a Warhammer 40K reference, tabletop war game.
So just for full disclosure, if you can't tell from the video, I'm 55 years old. I don't know what these video games are. So
no. Not a video game. This predates video games. This would have been, this would have probably been coming out around the time you were in high school.
Okay, so how old are you?
I'm 38.
Okay, so that's the age difference between us. So it's a full generation.
But it's the you would have had to be super nerdy.
I bet I have more kids. How many kids do you have?
I have 5.
Fuck. All right.
Gotcha.
3 books for you. I got 4.
I win. Take that. We also homeschool. Do you homeschool or did your kids?
What we do right now.
Right. Yeah, exactly. Exactly. Okay, next. Ninja Work 111 says, so is the DSP interview going forward after all? I don't know. I hope he DMs me. Protoman says, this is why you need one black friend at all times. Why is that? Ninja Work 111 says,
it's not actually that helpful, by the way. I mean, George Zimmerman had a lot of black friends.
Yeah,
he had a lot of black people in his community who testified very favorably for him.
Wasn't he fostering or tutoring two African American children as well? Something like that.
Here's one of the weird things about this case is when it became when the Zimmerman case became highly politicized, there was, of course, it was the Obama era. So Eric Holder was the Attorney General of the United States, and he sent the DOJ down to Florida to interview everyone in that apartment complex to discover if George Zimmerman had ever made a racist comment. And by the way, if he had, he would have been effed.
Oh, yeah.
One indication of him being racist, he would have been done, because that would have been a motivation for him pursuing Trayvon Martin that was inconsistent with a lawful purpose, right? A racist purpose. And when they charged him with second-degree malice murder, they had to prove malice. Well, how do you prove malice? Malice is, well, I have a pre-existing relationship with this guy and I hate him, or I have a generalized hatred of black people, for example. So they were desperately looking for any indication of racial animus on the part of Zimmerman. And they interviewed everybody in that apartment complex, including white people, black people, Hispanic people. And you know what they said about George Zimmerman in those FBI interviews? We love him. Right. He is our favorite person in this community. When something breaks, he helps us fix it. When he sees us carrying groceries into our apartment and struggling, he helps us carry the groceries in, stops his car to do that. When someone breaks into our apartment because the lock is weak, he gets us a new lock that's better and installs it for us. The people in that community loved him. Not only was George Zimmerman not racist, he was beloved by the people in that community. He was that weirdly nice guy in the community. He's the opposite of what he was characterized. Of course, that never got into the trial because that's all favorable evidence to George Zimmerman. But that's why when the federal Department of Justice investigates him, why are there no hate crime charges against George Zimmerman? That's why, because there was no evidence to support such charges.
Well, two counterpoints. One, maybe he was too nice and it was creepy. Two, he also did tell the dispatch that he identified Trayvon as black. So that is clear.
I love that you brought that up.
It's clear racism. Okay.
So this is one of the most prominent points of disinformation about that case. So when he called the 911 dispatcher, he's having a conversation with the dispatcher. He says, yeah, I see this suspicious guy. It's raining. He's walking around. He's looking in windows. And the dispatcher says, okay, well, what's he look like? Is he black, white, or Hispanic? And George Zimmerman says, well, he looks black. When the media replayed the 911 call, they deleted the question from the dispatcher.
Oh, yeah.
So all they heard was, yeah, there's this guy, he's suspicious. Pause. He looks black, which made it sound like George Zimmerman had a particular interest in this guy being black, or he had some racist motivation for identifying this guy. The only reason George Zimmerman identified the person's race was because the dispatcher explicitly asked him, is that suspicious person black, white, or Hispanic? Otherwise, he wouldn't have brought it up. But of course, the media's agenda was clear. They had to make Zimmerman look like a racist, so they edited the recording to make it look so.
Yeah, that was really bad. That was NBC, right? Who did that edit? Do you remember?
It was. And you want to hear a funny story you may not know. So the judge who was the judge at Zimmerman's criminal trial, I forget her name. I apologize. It's been a while. But the way Florida does it is they're constantly swapping judges from criminal to civil and back again. They swap them back and forth. So the judge who was the criminal judge at Zimmerman's criminal trial, when Zimmerman sued NBC, he ended up in civil court. Guess who his judge was? Same judge.
The same judge as the
judge. Same exact judge. So she, in the criminal trial, she had ruled consistently in favor of the prosecution. Every time she was challenged by the defense at the appellate court, she lost. She was reversed.
Yeah.
So she was highly favorable to the prosecution. When Zimmerman sued NBC, you know what she said? She was the judge now in the civil suit. She said, well, you're a public figure.
Yeah.
Well, who made Zimmerman a public figure? It wasn't Zimmerman. He didn't want to be a public figure. NBC made him a public figure. But she said, nope, you're a public figure, so you can't sue there. And by the way, about 3 years later, someone tried to shoot Zimmerman in the head as he was on his way to a doctor's appointment. And so now Zimmerman was the victim of that shooting attempt. And guess who was the trial judge in that criminal trial?
Oh, come on.
The same judge again. The same judge again. And now Zimmerman was testifying in her courtroom as a victim of the defendant who tried to shoot him in the head, who, by the way, got convicted and is serving life in prison now. For
At least she got that one right.
Yeah, or the jury did. Anyway.
Yeah. So wait, are you saying that judges aren't the be-all, end-all arbiters of truth or law?
So yeah.
No, I've heard from several people. Like I sometimes peruse law Twitter, for example, and I've seen them really just flat out say that once a judge rules on it, that's the nail in the coffin for the legality of an issue.
Law, right? Can't reverse it. It's impossible. They must have made a perfect decision. One of my favorite examples about judges is I'm going to age myself, and most of you're 20 years younger than me, so you may not know, but in the 1980s, there was a case in New York City called the subway shooting. Bernard Goetz shot a number of young black men who he said were assailing him.
Sure.
This is New York City, so he had no privilege to have a gun at all. He had the gun illegally. He says they threatened him with screwdrivers, and he shot them. And the case made it all the way up to the New York Supreme Court, which weirdly New York calls their court of appeals. It's bizarre. For those of you who are not lawyers, this doesn't matter, but it's a weird aspect of New York law. And I'm just going to call it the Supreme Court of New York for purposes of simplicity. And the judge who was the Chief Justice of the Supreme Court of New York changed New York law just so Bernard Goetz could be prosecuted. Because under existing law, he would not have been prosecuted. The grand jury refused to indict him. So the Chief Justice of the Supreme Court changed New York law so that Bernard Goetz could be prosecuted. And yes, obviously, this was another racially motivated case of the type we're talking about with Ahmaud Arbery. That same Chief Justice of New York State eventually ended up going to federal prison for kidnapping his mistress's daughter. The same judge, same guy.
Yeah.
All right. So for those of you who are thinking, I'll just put my life in my fate in the hands of a judge, even a state Supreme Court judge, these people are not infallible. They're human beings like everybody else. This particular guy not only effed Bernard Goetz, but he himself ended up going to federal prison and getting disbarred because he kidnapped his mistress's daughter.
Well, look, I mean, you can't let the mistress raise the kid as a single mom. That's not fair to the child. I'm just kidding. That's a joke.
The mistress had all the money is the problem.
Ninja Work one.
Very wealthy.
Oh, she was.
Oh, she had all the money. Yeah.
I see. Ninja Work 111 says, any idea what Superhound's motivation is? Attention. No, I don't. Superhound is a someone on Twitter who's filing copyright claims on behalf of people without their consent. So it's like he would flag someone else's video talking about me on my behalf, even though I never said anything. So
by the way, that's mostly why I'm not on YouTube, folks.
Yeah, it's a disaster.
All right.
Wait, are you suggesting that maybe you have a legal opinion that might be socially controversial?
I'm not suggesting that. Matter of fact. It's funny. So I'll share just a personal anecdote. The other day, my dad, who's 90 years old, is on Facebook, and I made a post about the Ahmaud Arbery case, and my dad liked it. He just liked it.
Oh man!
And I felt compelled to call him and say, "Dad, you can't do that because people will be calling me a racist for the rest of my career because of my commentary on this case. And if they see we have the same last name, your Facebook timeline will be full of allegations of racism for the rest of your life."
Well, now they know why you're a racist, right? Because obviously, that must have been taught to you by your evil father.
Yeah, whatever.
Yeah. Well, that's the hard part about having people can't separate. Not everybody, but people have trouble separating the idea that you can have a legal opinion, even one that's inconsistent with your values. But it's like, okay, but this is the facts and the law of the case. I don't even think it should be this way, but this is the way it is. And that's just a legal opinion. It doesn't mean that you want that to be the case.
No, but these are not reasoned decisions. These are for most people, they're emotive decisions. So if they've heard only the horrible racist propaganda on the media, they'll conclude this must have been a horrible racist event, and anyone who says otherwise must be a horrible racist. What I run into is not psychopathically insane people calling me a racist. What I run into is people who simply believe what the media narrative is, and therefore, if I'm consistent with that media narrative, I must inherently be a racist. I'm obviously what the media is saying is true.
Right.
And unfortunately, often the legal issues are complicated enough that you just can't talk them through it. They just don't want to hear it. I mean, and by the way, just like the Zimmerman case, so I know the truth of the Zimmerman case. I'm comfortable saying that because I watched every minute of the trial and the pretrial hearings. But I'm fully aware that the majority of the American public thinks that outcome was unjust. They think that Zimmerman was a murderer who got away with it. And I don't think they're bad people for believing that. I just think they got overwhelmed by the propaganda. And I fully expect that to be the case in this case. I think the vast majority of Americans, 99% of them, will forever think that Ahmaud Arbery was a black man murdered for the crime of jogging. That's what they will think until the end of times. I can't change those people's minds. All I can do is focus on the legal issues, whether or not it's in fact the case that these McMichaels can be proven guilty beyond a reasonable doubt. But for 99% of the population, that doesn't matter any more than any other societal myth or tale matters. They just believe it, and nothing will ever possibly change their mind. And by the way, a lot of those people will end up in, I hate to say it, senior law enforcement positions, senior prosecutorial positions. Some of those people will become judges, and they will believe that false narrative in those positions.
Now, do you think the McMichaels attorney is going to employ the sandwich defense? And if you don't know what that is, it's the idea that if you're taking a huge bite of a sandwich and you say Ahmaud Arbery's name, it actually sounds like armed robbery. Sorry.
No,
it was a dad joke. It was a dad joke I couldn't resist. Okay, Polyfrog64 says the 5 elements of self-defense: 1, stay back; 2, we will defend ourselves; 3, pull it out; 4, aim; 5, shoot. I don't know if that's the 5 elements. I think your list might be more comprehensive.
It's not the 5 legal elements of a self-defense claim, but it's a pretty sound self-defense strategy.
Right. I think when you held it up, I saw one of the big ones that it is avoidance, right? And that's one they do hammer on a little bit in concealed carry classes, but it really is. Look, if 2 people are fighting, or if there's a fight breaking out around you, maybe you shouldn't be where you are. Like maybe you just shouldn't be in a place where you might have to pull a gun and shoot someone. So get away from it.
So again, we it's important to differentiate between what's good judgment and what's criminal conduct. Good judgment is always the best way to win a fight, any kind of fight, a gunfight, a knife fight, a verbal fight with your mother-in-law, is to not be there. Be someplace else, right?
Don't go to your mother-in-law's house ever.
Absolutely. For God's sakes, don't go there. But if you can avoid the confrontation in the first place, and listen, folks, this is not legal advice. This is personal advice. If you have the option to not be engaged in that fight, you can, consistent with safety. I'm not saying increase your jeopardy, but consistent with safety, you cannot be in that fight and you don't take advantage of that opportunity. You deserve to buy me another German motorcycle. I'm sorry. You brought it on yourself. How many costly German motorcycles? If you cannot take advantage of the opportunity to, with complete safety, walk away from a confrontation, and you decide to instead wave a gun at somebody or shoot them, you just bought me a motorcycle. That's how this world works. Don't do that. If you can get away safely, get away safely.
How are you on Italian motorcycles?
they're very hard to maintain. I love Ducatis. They're so effing sexy. They're fucking gorgeous. I mean, they look great, but I'm 55 years old. It's hard to fit on them properly anymore. So mostly I do large cruising type BMW motorcycles these days.
Oh, okay, those are the BMW, the traveling bikes are just, they're gorgeous. I'm with you. I mean, Ducatis are cool.
I'm looking at a K1600 right now. I am absolutely drooling over. Why not a car? I see in a comment, why not a car? Because cars suck. Cars are what women drive.
Oh, I love it. I love it. Angry Baneling says, Andrew, do you know any gamer words? Lol. The proper answer is no. Let me help. I'll help with the internet stuff. Bloody Thumb says, thoughts on firearm insurance like USCCA?
Okay, so that's not firearms insurance. It would be somewhat more accurately be called self-defense insurance. Basically, what they promise to do is pay your legal expenses if you're involved in a use of force event. Now, before I get into anything substantive, I have to disclose I am sponsored by CCW Safe, which is one of these providers. So take that potential bias into consideration. But there are reasons why I selected them as a sponsor. One is a lot of these programs, they have a cap on coverage.
Right.
The last time I looked at USCCA, this is the last time I looked. So please, folks, don't take my word for this. I'm not trying to defame anybody. But so look at their website yourself. But the last time I looked, it was $250,000 was the cap on coverage. Folks, $250,000 is a lot of money. It's a lot of money. But if you killed somebody and you're being prosecuted for murder or manslaughter, I'm sorry, it's not that much money. Most of the cases I consult on that are killing cases, we go through 150, 200 grand pre-trial before we get to trial. We go through that much money. So if your cap is 250 and you burn through 200 pre-trial, what's left for trial? $50,000 sounds like a lot of money, but it's not a lot of money in a trial. I'm sorry, it's just not. And so one of the things I like about CCW Safe is there's no limit on their coverage. They will cover you, and not just for the trial, but they'll cover you. What if you go to trial and you have a hung jury? Say your defense lawyer is awesome. He gets a hung jury. Is that a win? You tell me.
No, it's not a win. It's an I mean, it's better than a conviction. But,
right.
But the DA still has the opportunity to bring the case. It's a mistrial.
Right. So imagine if you spent every penny you had to win that trial, which you will do. I promise you, you will do that. You will spend every penny. You will sell everything to not spend the rest of your life in prison. And you get a hung jury. And the prosecutor says, we're going to try him again. What resources do you have for the second trial? You get nothing.
Yep.
You get nothing. It's all gone. And by the way, that very expensive lawyer you had for the first trial, say bye-bye to him. He's not around anymore. You got a public defender for the second trial. And public defenders don't suck. I've worked with my first experience in the law was working for the public defender's office in New York State. A lot of public defenders are world-class attorneys, but they are all massively overworked. Okay, you're not getting the attention from a public defender that you would get from an attorney you're paying $300,000 to for obvious reasons. One of the things I like about CCW Safe is if you get retried, they cover the retrial. If you appeal, they cover the appeal. These other programs don't do that. And all these things cost a lot of money, folks. So anyway, make up your own decisions. Whether or not anyone should have one of these programs, whatever the variety, is frankly a personal kind of risk tolerance issue. It's a basic insurance question issue. Do you need car insurance? Well, they make you do that. Do you need homeowners insurance? Well, the mortgage company makes you do that. Health insurance. But do you need umbrella insurance? Well, I don't know if you need umbrella insurance. How would I know? It depends on your circumstances. Do you need self-defense insurance? I can't answer that question for you. Only you can decide that. Is CCW Safe, the company that sponsors me, the best choice for you? I don't know the answer to that. They're the best choice for me. I'm personally a member of CCW Safe, but whether or not they're the best choice for you is a decision only you can make. You have to look at the individual companies and decide if they're a good fit for you.
Gotcha. Thank you for I've always been kind of curious on those programs, and people ask me about them. I say I answer kind of how you did. That's an insurance question. I don't know. That's up to you. Polyfrog64 says, I live in California. Stay and fight. We can't run anymore. Well, start breeding a lot and raise a bunch of like-minded children. Oh, by the way, if you're not raising children, you're not helping whatever fight you have. If you think you can't bring a child into this world because it's just too bad, then you have surrendered, and you need to man up.
Demographics is destiny, folks.
Nova Zero says, let China invade California, then liberate that entire state to the point where it can't be a state anymore. Fixed. I ate the juice says, Andrew, you have nice eyes. May I tongue massage them?
Happily married, dude, but sure. No. Answer.
You heard his first answer. Don't listen to his conflicting answer. No, I'm just kidding. Juan says, thoughts on the judge in the Flynn case leaving room for amicus briefs before deciding to dismiss the case. That's a complicated question, isn't it?
It's not a use of force case, but that judge is clearly beyond bounds. It's pure, obviously political theater at this point. It's one of the things I hear is the judge says, well, Flynn took a plea, confessed to the underlying crime, and now I'm going to hold him in contempt or claim he committed perjury. And folks, that's not real world criminal defense. That doesn't happen in the real world. Defendants all the time take plea deals and then later argue that the plea deal should be considered illegitimate because they were coerced or they had ineffective assistance of counsel, or whatever. There's a ton of reasons why you might claim that the plea deal you took is not legitimate. They never get prosecuted for perjury or contempt. That would be insane. They're simply seeking justice, right? They're saying my plea deal was unjust. I'm seeking justice. You don't get convicted of perjury because you're seeking justice. Flynn can't be convicted of perjury because he's saying, hey, the federal prosecutors, by the way, who are secretly working with my defense team that I didn't know about, came to me and basically said, hey, nice son you got there. Be ashamed if anything happened to him. Maybe deal. I mean, that was the fucking deal. Sorry.
You're fine.
And now he's saying, wait, no, I'm not in that position of weakness anymore. I can contest that was a coerced, that was an extorted plea agreement. You don't get charged with contempt or perjury for that. That would be insane. He's basically saying, well, when I took the deal, it was unjust. I was being coerced. I was being extorted. You can't criminally charge people for saying I was being treated unjustly. Now I just want justice. That's not a crime.
Just as much as if I come up to you and I hold a gun to your head and say, you're going to buy this automobile from me. And then you agree because there's literally a gun to your forehead to buy the automobile. I can't then sue you and force performance. Right. And force performance on the contract. Your defense is he had a gun to my head. I was just saying whatever I wanted to get out of it. Didn't they also withhold exculpatory evidence against him?
Well, they always do, don't they?
No. The prosecution side is perfect and flawless, and they're always acting within their ethical obligations. I only love the prosecution.
So here's an example of how prosecutors can do this and not be sanctioned. They can be very clever. So this is an example from the George Zimmerman case. The prosecutors got Trayvon Martin's cell phone. Yeah, and they had a very high tech device for extracting even deleted content from the cell phone, which you need a very costly device to be able to do, which, by the way, the defense team did not have. They did not have this $200,000 device to get the deleted content off the cell phone. So the prosecution had this device. They got all the deleted content off the cell phone, and their technician gets all this data, and he writes up a summary report, like a cover sheet, like file 1 is this, file 2 is this, file 3 is this. And some of this was evidence that was not favorable to Trayvon Martin. It was Trayvon Martin smoking weed, holding guns, talking about getting into fights, talking about using the exact same attack technique in a street fight that he ended up using against George Zimmerman.
Right.
Which is obviously highly relevant to the merits of the case. Well, the prosecution saw this report and they decided to modify it. They didn't modify the DVD. They modified just the cover report. They deleted all that incriminating evidence about Trayvon Martin, which would be, of course, exculpatory evidence for George Zimmerman. They took it off the cover report and they sent it to the defense. And we're talking thousands of files. So the defense, by the way, it's just 2 attorneys, not 8 prosecutors in their whole office. The defense is 2 attorneys. They get this report from the prosecutors and they look at the summary report and they say, well, it looks like there's nothing here to help us. Except there was. All that evidence was still on the DVD, but they did not have the $200,000 machine to look at the DVD.
Why didn't they spend thousands of hours going through every single piece of evidence? I mean, why didn't they do that?
Only 24 hours in a day.
Well, and because
every day the prosecution was raising an issue that would keep the defense up all night researching case law.
Yeah.
To hand in a brief, a filing the next day. So they were effectively working 20 hours a day already, and then having to show up in court the next day and perform at a World Series level in that case.
They're $100 an hour attorneys, right?
Well, no, they're not.
No, I mean that's the trick, right? The state pays their prosecutors.
They're free. Yeah, they're working anyway, right?
Right. They're working. Anyway. They also work every single day with that same judge. Just so we're clear, they're on a first name basis with the judge, and their office is down the hall. That's one issue that we really need to fix, in my opinion. But 2, for the state, prosecution is free. It's a function of just budget. The prosecutor's office has X amount of dollars, and if it needs more, it will eventually find it. But there is no hourly concern. There is no $500 an hour bill to go through 200 hours of DVD or of a DVD cell phone evidence where you have to read every single text message that this kid ever deleted.
And by the way, the defense in the Zimmerman case ultimately realized that this incriminating evidence was on the DVD, and they asked the trial judge to sanction the prosecution for not disclosing this evidence. You know what the prosecution said? They said, well, sure, okay, we deleted it from the cover report, but it was on the DVD. I mean, if you'd taken 200 hours to look at every file on the DVD, you would have found it. We gave it to you. In that sense, we just hid from you the easy way to know that information was there. And that was acceptable to the trial judge.
Yeah.
I mean,
well, Zimmerman should have given them $100,000 to do so.
Right. When the stakes are a human being's going to go to life for the rest of their lives, which will probably be a week in a Florida prison. I mean, it's truly contemptible. It's why I think I don't know anything about the merits of George Zimmerman's current $100 million lawsuit against whoever. I don't really know anything about it, but whatever he gets, he deserves.
Yeah, the guy who did the documentary sent me an email a long time ago saying that he might be willing to come on the show. So I might follow up with that. If I do, I'll let you know so you can watch it.
He's contacted me too. I don't have anything positive or negative to say about that guy. I just don't know anything about him.
Sure.
It's simply, for me, it's simply a matter of I focus on the criminal dynamics of use of force laws. So once things get into the civil realm, it's just not interesting to me.
It loses its luster. Yeah. Keck7Go says DSP Redemption arc hype piss-free interview win, hopefully soon. That's disgusting. At Sushi Kano says, cheers, Nick and guest. It's my birthday today. Going to celebrate by spending my taxes and stimulus later today on a suppressor, then eating homemade sauce on drumsticks. Enjoy a shot or a drink for freedom. Hey, thanks, buddy.
Suppressors are awesome.
They should not be, are they still Title III items?
I confuse the titles, but they're $200 tax stamp.
They should not be. That's ridiculous. A suppressor is
sold in every hardware store in America.
Right. They should not be the same as Actually, I think that the NFA should be repealed in general because why can't I own a fully automatic weapon?
Of course. Of course. By the way, for folks who don't know me, I consider myself a Second Amendment absolutist. So as far as I'm concerned, every preemptive gun law that infringes the rights of law-abiding, mentally sound Americans to keep and bear arms is facially unconstitutional. I don't even know why that's a legal issue. Now, if you're not mentally sound, if you're not an American citizen, if you're not law-abiding, well, then you're in a different bucket. You get treated differently.
Right.
But if you're a law-abiding, mentally sound American citizen, the right to keep and bear arms shall not be infringed. It's not a complicated concept or amendment. It's very straightforward.
Do you think Scalia botched the Heller case?
Botched, I think, is a strong word. I think he was doing what he could to get a majority. I think it was a very important majority. I think getting the majority compelled him to hedge around the edges. It's not the decision I would have written if I had, ultimate authority over all things having to do with gun law, but neither did he. So he had to work with what he had. And I think working with what he had, he did a pretty good job. Unfortunately, he left a couple of huge gaping holes through which the gun controllers are still driving their fascist demands. Reasonable gun control is okay. What the fuck does that mean?
Right. I wanted him to establish strict scrutiny on Second Amendment issues. I don't
think he had that power.
I know, but I can't see why it would be anything less. I mean, it's a fundamental right. It's clearly laid out.
It's an enumerated constitutional right. How could it be anything but strict scrutiny?
Right. But
nevertheless, listen, the federal district courts are in open rebellion against Heller and McDonald. There's no other way to describe it. They're in open rebellion. They're fuck you, Heller and McDonald. That's what they're doing. But the only entity that can hold them down, that can call them to task, is itself the Supreme Court. So if they're not willing to do it, who the hell's going to do it? Congress can't do it. Trump can't do it.
And I think the Supreme Court were absolute cowards on the New York case, suggesting that it was moot. I don't believe it was moot at all.
It's hard to know. I mean, clearly it wasn't moot. Obviously, that's ridiculous. They would never do that with an abortion case. They would never.
That's what I was going to say.
The pregnancy happened, so we're not going to deal with this issue. They say, "Oh no, fuck no, we got to deal with this." So the next lady with a baby, gets addressed.
Right.
Of course, that's what they should have done here. But the question is whether or not the justices thought. Let's hypothetically imagine there are justices favorable to the Second Amendment who want a favorable outcome. They may look at that case and say, this is not the case, so we're going to let it go. We're going to wait for the next one. Yeah, that's not malice. That's being opportunistic for the best chance to win.
As long as we get one of those cases. They've held off for 12 years now from even hearing.
Listen, you want different Supreme Court rulings, elect different presidents who appoint different Supreme Court justices who give you different rulings. Anyone who thinks the Supreme Court is making these decisions based on legal analysis is so naive that they should still be in a crib sucking on a baby bottle. It's
right.
Modern politics is all, what team are you on? Period. Whatever team you're on. When you look, okay, I shouldn't speak for other people. When I read gun control favorable positions out of the Ninth Circuit, or I read decisions from people like the Supreme Court, like Sotomayor, I read those decisions. They are babble. They are word salad. They are not legal reasoning. They are words being shouted out of a hole in someone's face to support whatever team they happen to be on. That's all that those are. And I'm sorry, that should not be the way. I would prefer that was not the way American society was structured. But if that is the way it's structured, guess what, man? I'm going to vote for my guy to be the mouth hole making the noises so that my rights are not stripped from me.
Have you considered that at least one, if not more, of the justices may be a actual lich who is unkillable?
I don't know what it is. I do believe that at least one or more of the justices is probably a victim of blackmail. There's a good reason to believe that.
I don't think Ginsburg is allowed to die if Trump wins in 2020.
Oh, she'll still be a Supreme Court justice 100 years from now.
think so too. Skeet Neat says you can't flim flam the Zim man, Nicky boy. That's true. Nuvi says BMW bikes may be the indestructible Honda of motorcycles, but they are so ugly. Ducati all the way.
Fighting words.
Yeah, no kidding. And from what I've
there's no debate that Ducati is a way sexier motorcycle than a BMW. I would ask in turn, have you ever done a valve adjustment on a Ducati? That is not a pleasant experience.
I have not. I'm not handy. Nova Zero says autopsy.com free training expires today, so you can learn forensic stuff for mobile stuff. Since Andrew brought up the expensive tech stuff, thank you for that. Colin,
I've seen all the dead bodies I need to see.
No, I think it's a tech autopsy. So like recovering deleted stuff, I think is what they were saying.
Oh, I'm sorry, folks. Listen, I appreciate the input. I genuinely do. I will never be tech savvy for the rest of my life. I'm not going to seek to do that. I rely on other people to do whatever shit they do on Google or whatever way back, or I don't know what the hell they do, but they send me stuff. So when I get stuff, I use it. And if they don't send it to me, I'm just, unless the government will give it to me, which sometimes they will. And
right.
Sometimes they tell me to piss off. That's the way it works.
Colin 4486 says, God bless you for defending the Second Amendment. I think that's to you, but thank you. Okay. Bro Tato says, shall not be infringed. Judges today. But what does this mean? It is funny how unambiguous words get made ambiguous real quick when public policy and politics are on the line. Yep. CJ says, in the Second Amendment, yeah, but who determines you're mentally sound? The APA these days, please.
Yeah, the burden is on the state. The state has the burden of proving you mentally unsound. Until they do that, you're just like a crime.
Right.
You're innocent until proven guilty. You're mentally sound until proven unsound. So if the state wants to put in the effort to prove people mentally unsound, I guess they can make that effort. But in my opinion, until they do that, the presumption has to be that you're a normal, law-abiding, mentally sound American citizen, and you can have whatever gun you want. Because guess what, folks? Normal, law-abiding, mentally sound American citizens, whatever guns they have, I don't care if you gave them a Sherman tank, they're not killing people with them. Criminals are killing people with guns. Law-abiding American citizens who are mentally sound are not causing anybody any harm with their firearms.
I agree. And I think the fear that some people might have is against these prescriptive lists. Like, well, if you have depression, then you're mentally unsound. If you have this, no, that's not what that means. The state has the burden to prove you mentally unsound, not by just merely prescribing a list of unsound conditions that you may or may not fall into. Those are different things.
For the political opposition, I would say, well, what's the standard for not being able to vote?
Exactly. Right? Yeah.
Mental level you set for not being able to vote, that should be the same level for not being able to have a gun. So you want to be able to say just being depressed or having anxiety, you can't have a gun. All right, that person can't vote. You know what? The left won't accept that because they're riven with people with anxiety.
Yeah, never. Sakaki Onsai says Roberts equals blackmailed. Sotomayor equals in bad shape. Maybe. Nuve says, I have done a valve job on a Ducati 900. I will admit I didn't do it twice.
Yeah. All right. Okay.
And then I got two more. Bad Dragonite says, what are your guests' favorite Chaos God and whiskey? We talked about the favorite Chaos God. You're not a whiskey drinker, though. What's your drink of choice?
I am not, and it's not because I have anything against whiskey, but every time I drink whiskey, people tell me interesting stories about myself the next day that I was not aware of previously. So I've learned since teenage years to stick to things like beer and wine.
Okay, gotcha. Any particular favorites?
No.
Okay, just curious.
I just like to have a good time.
Bad Dragonite says the dispatcher asked if he was black, white, or Hispanic. Plot twist: it was the Asian dude the whole time. So there.
That was very funny.
There we go. Thank you guys for joining us. Andrew, do you have any closing words for the audience tonight?
No, I would just encourage people, if they like the kind of stuff I talk about, take a look at our website, lawofselfdefense.com. We always have some free stuff there that doesn't cost anything, so you're not obliged to spend even a penny. But I will say, in my experience, most of the time when people go there, they end up taking advantage of the stuff we have to offer, whether it's books or courses or becoming a member. Again, your call, whether or not you want to, is totally fine. But I think you're doing yourself a disservice if you don't learn what the law of self-defense actually is. If you feel like I was credible talking about these legal issues, that's what you learn with the content that we teach. And folks, if you can make yourself look like you're difficult to convict, guess what, folks? That's legal body armor. You've just made yourself hard to convict. You don't look like a vulnerable target for a prosecutor. And most prosecutors don't like hard cases. And the ones that do, if they take you to trial, you still want to be a hard case. You still don't want to be convicted. So learn what you need to learn. And most of the stuff we do is $5, $10. It's not a ton of money.
Yeah, so you can find the Law of Self-Defense link in the description of the video. Thank you, Andrew. If you want to hang out for just a second, we'll say goodbye to the guests, and I like to say goodbye to my guests in private.
Sure.
So thank you guys for joining us tonight. Check out his website, and we'll see you tomorrow. I will have a big brain panel. Well, at least one of the big brains on tomorrow. We'll see who else, and we'll be talking about the Flynn stuff, and we'll be drinking liquor and having a good time. So hope to see you guys then. Have a good night. Peace. Peace.